CRL is 730 and security of 23 matter. So I for bail matter. The CRL
I for bail matter in CRL.
another one 344 by 25 matter. So I for bail. Like
I will pardon my lord. Before vacation, I made a mention before your lordship that a senior citizen age of 91 years, he has filed a case and since 2018, that matter may be taken.
Which case? What type of case?
There is the order of case, Central Administrative Tribunal.
All right, give it.
now the contempt matter. Other three matters are already implemented. After conference by the Honorable Supreme Court.
Give it.
Yes,
It's a read, Your Lordship. We are struggling for regulation also since 2014, Lordship.
Please give it.
Press brief.
I want to make a mention about this is an after notice matter.
Hmm.
This is an after notice matter where the claim of the family pension by the petitioner has been rejected by the CAT.
Please give it.
Lordship directed to list of matters
Well,
on 10th of February, but all matters not.
It's a read petition challenging the order of the DRT and the appellate court. On the ground, they have limitation only, they have rejected it.
So if DRT has rejected, you have to go in appeal.
Appeal, they have also rejected.
Oh, all right.
There may be pardon to make a mention, Your Lordship. This rate appeal pertains to 2015, Your Lordship. Since the matter is still pending, the opposite parties have issued a eviction and demolition notice against the appellant, Your Lordship. It is scheduled to be held on 19th of June, Your Lordship. That is tomorrow. I'm requesting if the matter can be taken up tomorrow on the board, Your Lordship.
Give it. Give it.
Much appreciated. Your Lordship, I have attached the notice and I have filed an IAT with that.
All right.
Okay.
Lordship, item 41. Conducting counsel mother health condition is not good. She has hospitalized.
Which matter?
Item 21, OSRTC.
Just a minute. 21, it's a, just wait, let us, in the matter, it's just.
Item 24.
Hmm.
Last Sunday, I appeared in the Union of India. This matter today appeared on senior for the petition which time they granted.
You are for the Union of India.
Union of India. All the opposite parties in the East Coast area.
What do you want?
Which time they granted.
For what purpose?
Today and received by.
You are, the counter have been filed. Counter has been filed and then rejoinder has also been filed. As it appears from the cause list, item 24, no?
My bad.
What further you want?
But today an appearing from the Union of India. Brief is received today, my lord, tomorrow.
Okay. Give it.
Sorted.
One so, what's the
Ajay Kumar is.
appearance or vocal of managers of the agent, which is taken on record, the name of the Land Council for the Union of India is reflected in the cause list. It appears that the pleadings are complete. The Land Council for the Union of India seeks for an adjournment. Or you want 1 week or 2 weeks? 2 weeks. The Land Council for the petition has no objection to such adjournment. This matter. We shall call for it. Yes.
Item number 23, may kindly permitted to withdraw.
Memo file disposed of.
Item number 10. Yeah, Mr. Patnaik, Mishra Patnaik, you are undergoing Sahoo paper next week.
What if you have got power in this case?
Yes, yes, yes.
What is your good name?
Manas Anjan Sahuja, MSO.
Mr. M.R. Sahoo, Council, appealing for Mr. Ms. Chandra Patnaik submits that the senior is not available and the matter may be adjourned for
Next week, any day.
Of this matter, we will commence in from 2020.
Obliged.
Yes.
Supplemental list, item number 1.
Yes, sir. Item?
Item 27.
Yeah.
In this case, my Lord Summary is appearing for the.
Today
Today I have been allocated for the appellants.
You are for the?
Appellants, my lord, the government of India.
Union of India.
Union of India, madam is appearing.
No,
I am.
You are appearing,
he
okay?
is appearing.
Yeah,
My law senior is appearing for this or opposite party.
opposite party, yes. What do you want?
My lord, my law senior was saying it was not been noticed for that it may be taken off for fresh admission.
Notice here,
Not
let not
notice,
issue.
He has already filed the counter
So,
and that will be taken.
you have received the copy of the counter.
Yes,
bill.
yes.
If you want to file any rejoinder, file, otherwise you will hear the matter, what is there.
Yes.
Once counter has been filed, are you ready, madam?
Yes, ma'am.
Okay, let it be there.
Supplemental list, item number 1,
It's leave of your lordship, my lord.
One,
I would
I
beg.
am today appearing for the appellant's petitioner. My lord.
Okay. You have received the copy of the writ
No,
petition.
no, brief has not been issued because.
It was filed by him and then the panel changed. Then he has again, his position has been restored and he has been entrusted with the
I
place.
was the railway advocate at that time. I had filed the petition and thereafter railway merged with the central government.
But I would beg before your lordship. No, writ petition has been filed by whom? By the railways, in Union of India, East Coast, it is by East Coast Railway. So you will appear for the petitioner.
Yes, ma'am.
And Mr. Das, you are. I am for the opposite party number 2. And have you filed the counter affidavit or what? In this case, my lords, this has become infructuous. I will satisfy your lordship subsequently. Your lordship may bring
Is it
these
infructuous?
matters to your lordship's board.
Are you disputing?
After some time, my lord, after 4 years, again it is returning to me.
Yes.
I have to.
No, you go through and
Yes.
please examine the submission
Yes.
of Mr. Das, whether by passage of time the matter has become
Development
fructuous or
takes
not.
place. I'll.
You are having the copy of
Yes,
the
yes.
petition. So please,
I'll-
you can
One
take.
line submission subject to your lordship's
Yeah.
approval. Your lordship may bring this matter along with another writ petition which is filed by the railways. Probably my friend.
Please
may not be knowing
give
it.
the number.
Yes, I will give the number.
We are bringing it on the Monday and let him examine in the
Grateful,
meantime.
yes.
All right.
WPC number.
Please give it in
I
writing.
have.
Mr.
I'm good.
S.S. Das, Land Council, appearing for the opposite party submits that WPC number such and such is connected to this writ petition and the matter will be listed, this matter will be listed along with the said WPC. He further submits that by passage of time, the matter has become infructuous. Land Council appearing for the petitioner seeks some time to examine on this point. Mr. Siddharth Shankar Mahapadra, Senior Panel Counsel, Government of India for the High Court of Orissa, files the appearance memo which is taken on record. Let him examine the submission made by Mr. Das regarding infructuous of the matter. Matter will be listed on 23rd June 2025 with WPC number so and so. All right, yes.
Grateful.
item 2,
And the name of Mr. Sudan also shall be reflected in the cause list.
Your lordship, on behalf of Impleadment.
Yeah, to my lord. The chairman is GB, the opposite, there the state is,
Yeah.
the state authority is involved, so I cannot appear relatively. Some other day I have already instructed.
Adjourn this matter for some time. On behalf of Impleadment.
All right, you are for the petitioner. Mention is made on behalf of the petitioner for adjournment. The Land Council for the petitioner seeks for adjournment. Look at this matter. What time you want, man?
At least 2 weeks.
2 weeks. 2 weeks.
See, this matter was listed before Lok Adalat more than twice. One,
Several times listed but did not cooperate,
three,
petitioner did not cooperate.
4,
Ultimately, on 17/3/24, there is an order that the opposite parties submitted that the matter cannot be perhaps cannot be settled in the local adalat. That is the reason why
ଏବେ appear କଲେନି ସେଟା
Six time it was listed for National Lok Adalat.
କେବେ ବି appear କରିନାହାନ୍ତି ସେ ଜାଗାରେ contest in a retired ISFSR avail a loan of 2 lakhs he not wants to return, that is the query.
ठीक है चलो so list this matter in the week commencing from 2 weeks upward. Yes, next.
Item 3.
He has become infructuous. Wherever as the transfer away from the
Which one?
SAT 3. SAT to Honorable High Court. Honorable that has transport and dispose of already since 2020.
Which one?
Item 3.
Disposal.
Yes, that has transferred. Wherever was the transfer away from
Oh, I
SAT
see.
to
Okay.
Odisha High Court. That is single matter. It is so motor transfer and dispose.
This writ petition has been filed by the petitioner for a direction to the Land Odisha Administrative Tribunal, Cuttack Bench, Cuttack, to transfer the OA number 2818C of 2015 to this court for hearing and final disposal. None appears for the petitioner. The Land Council for the state submits that OA 2818 of so and so
Limited transport and
transfer, which was renumbered as WPC number OAC number 2818 of 2015, and the same has been disposed of by order dated 22/7/2022. He has produced the copy of the order, which is taken on record. In view of the submission, this writ petition has become infructuous and accordingly disposed of.
Item 4.
Then unless petitioner damaging annexure 6, wherein the opposite party legal was one has confirmed the order passed by the Lord DRF Dharmasa. Here, manner the fact of the case is that petitioner has applied for one.
Just a minute, you are challenging annexure 6.
Yes.
So, there is no other forum available to you. Are you sure? Which is the provision under which you approach the authority who disposed of annexure 6? Which act and which provision?
Annexure 4 is my
no.
representation case.
Just tell us the act. Tell us the act. Let us examine that. There is no other forum available to you.
Electricity Act, section
Which is the provision?
42 of section 42 subsection 7 of the Electricity
Yes.
Act 2000.
Electricity Act,
2003 section
2003.
section 7 man.
section
42 man.
It is electricity Act 2003.
yes, which provision?
Section 42.
Yes, man.
Yes. No, it's there. Please read it over. Provision.
The ombudsman shall settle the grievance of the consumer.
Who तार who subsection दा
Section 7 man.
कहाँ कौन है? हाँ.
The ombudsman shall settle the grievance of the consumer within such time and in such manner as may be prescribed by the State Commission.
Okay, so
If he doesn't do, then what happens? What is the remedy? Huh?
Read will line.
no, that is exactly what we searching for. Whether any other remedy available against the order of the
Embussment.
or you are to oppose. That is the simple thing we want to know.
Appeal provision is there or not?
No, ma'am.
Yeah, is there.
Who used to appear for the opposite party, the electrical so and so.
Mr. L. Maharana used to.
Have we given a copy to him?
No, no, I am not. It is-
There are panel of counsel or what?
Yes, Lalit Maharana.
So have you given a copy?
Examination है तेरे से.
No, it's all right, but
Why can't you go to regulatory commissioner?
we just want to examine whether you have got any other forum to challenge the order passed under Annexure 6 or not. So you do one thing, you serve a copy on which counsel you say?
Lalit Maharana.
Lalit Maharana. Okay, we will reflect his name in the cause list. It will be listed tomorrow, and we just answer to our query that if any other forum is available for the petitioner or only read petition is maintainable. That much we are.
From day after tomorrow. His number.
Hey, there is a appeal.
111.
Appeal, regulatory commission will take into account.
Appeal to appellate tribunal. Any person aggrieved by an order passed by an adjudicating officer under the Act or an order made by the appropriate commission.
They
Under
have
this
to
Act,
go to
may
regulatory
take
commission, regulatory commission will pass the order, then it lies before the electricity tribunal. in Delhi. Just put it there for 2 hours.
Acha. The Mr. Acharya, learned counsel for the petitioner, submits that usually Mr. Lalit Maharana is to appear for the opposite party, and he will serve a copy of the writ petition on Mr. Maharana during course of the day, and the matter may be listed day after tomorrow. This matter on 20th of June 2025, indicating the name of Mr. Lalit Maharana in the cause list, right? Okay. Acha, got the understand. The petitioner has challenged the order dated so and so, passed by so and so under in case number so and so under Annexure 6. Let the Land Council for both the parties examine whether any other forum is available for the petitioner to
Please let them examine the maintainability of that petition.
let both the Land Council examine the maintainability
Of
of
the petition.
the writ petition. No? Yeah.
Item 5,
Sure. That's what she says.
item 5,
Vilas Mishra. Password but one.
item 6,
No problem. Get to withdraw. I to file a memo. File a memo. Just what is your good name, Land Council?
Ranjan Kumar Nair.
All right. Mr. Ranjan Kumar Nair, Land Council, files a memo to withdraw the writ petition.
item 7,
Mr. Patnaik, you are appearing for the opposite party?
Yes, my lord. That item 6, my lord, I was
All right.
directed.
Mr. Abhijit Patnaik, Land Council for the opposite party is present. We are just recording your presence. All right. The memo is taken on record. The writ petition is disposed of as we come. Please file the memo.
My lord, I'll do.
Yes.
My lord,
item 7,
in connection with the item number 7, I am for the petitioner, madam.
Yes.
In this matter, I taken the loan account will become LPA. And thereafter matter was discussing a settlement issue was coming to the tune of rupees 1 crore 35 lakhs. Out of that 1 crore 35
I may
lakhs,
be pardoned,
I
my
have
lord.
paid 60 lakhs.
But in item number 6, I seek for a passover, my lord. Mr. Patnaik will appear as the counsel of the opposite party, my lord.
Patnaik has already appeared in this put up.
Whether you are
I'm
too
sorry.
late, Learned Counsel, Mr. Patnaik is present, yes. Item number 7, yes.
So I have deposited rupees 60 lakhs. So 75 lakhs ought to have been paid. But the fixed remains, bank has not issued. After receipt of this amount and the proposal has not been taken any decision. My lord, they have adjusted the money, which is also the beyond the.
You want to know the outstanding dues?
No, my lord.
Then
After a discussion with the bank authority, there was a settlement of rupees 1 crore 35. I have accordingly, I have
any
submitted a
instruction
proposal.
taken, Land Counsel?
Proposal.
My lord, the essay is pending before the lender DRT.
Oh.
The applicant already in 2024, 150 of 2024 essay is pending. In the meantime, they filed an application before the lender magistrate to review the own order. The lender magistrate has reviewed the
No,
own
but
order.
what he says is the matter is settled for 1 crore something.
Yes, sir.
Out of that, he has paid 60 lakhs.
And 75 lakhs had to be paid by March 2025. He has not paid that one.
One letter has not come from their level. My lord. They have not received. Let them show that.
Are you interested to pay
Yes, 75? Definitely.
No, but that's 3 months passed now
3 months.
We used to
Just
charge
since
interest.
the matter is pending
before the DRT. Yes.
DRT, but he is giving a proposal. We are just adjourning the matter to some other day. Please take instruction that he is ready and willing to deposit the entire dues. So how much amount you want for clearance?
Where is the settlement? Show us. Where is the settlement?
My representation is page number.
Representation, settlement, show me. They have agreed for 1 crore something.
My lord, after discussion, we paid the 50 lakhs DD, 10 lakhs. Another
Nothing in written.
written that discussion, we will issue the letter, my lord.
Let him see.
Accordingly, I have paid. Our Honorable Supreme Court categorically stated on the strength of the OTS application, if I have deposited, if the decision will not come up, that amount cannot be adjusted. Like the Kutte Agency Private Limited.
Just a minute, we are just keeping this matter to next week.
My lord.
Let the Land Counsel for the
I am serving the copy of the writ petition also.
Right, Mr. Sahoo, Land Counsel appearing for the petitioner. So I'll take copy of the writ petition and the Land Counsel for the opposite party in court. He submits that as for the settlement between the parties, a sum of rupees
1 crore 35 lakhs.
कितना deposit
60, 50 lakhs and 10 lakhs.
60 lakhs. 60 lakhs have already been deposited with the bank.
75 ought to have been paid, but they have not given a written.
Petitioner, as per the settlement, was required to pay an amount of rupees
75 lakhs.
And
By 31
by 31/3/2025, and the petitioner is now ready and willing to deposit such amount. The Land Counsel for the bank seeks some time to obtain instruction regarding the settlement. So also the balance amount which is to be paid by the petitioner for clearance of the outstanding dues, and the 6 for an adjournment. Put up this matter on, you want it on 23rd?
Yes, yes, Lord. It will take 2 days to take.
23rd business matter.
And may I submit one thing, Lord? Along with this proposal of paying that amount, if the timeline comes, it will be easier for the bank
Because
to
you
accept it.
see, there is no document. My esteemed brother asked him whether there is any documentation of that. He said no. It is just an oral.
Yes, accordingly.
What happened is he gave an OTS proposal and spelling out that 50 lakhs, 10 lakhs and 75 lakhs I'll pay.
and he has paid 50 lakh, thereafter 10 lakh.
Yes.
And he was expecting that you will respond to it. You have not responded. So therefore, the final payment he has not made. That's what his case is.
His case is.
Hmm.
But today he is willing to pay the 75 lakhs. There's a 3 months lakhs also.
Hari, you take instruction, it's all right. But you see that document is already there about the receipt of 60 lakhs. That is annexure 1 is there.
Not disputed.
So representation, so that is not disputed.
You only ask to the bank how much interest you want on the 75 lakh for 3 months.
The only thing is,
very
if
simple.
you say that 75 lakhs or with the interest within such period, bank will agree or not agree. That will be easier for
Just,
you.
we are keeping it on 23rd, take the instruction.
Okay.
And so that, yes, put up this matter on 23rd of June 2025. Yes.
On that 75 lakhs, he will pay interest for 3 months. Delayed payment.
But within 15 days, 10 days, 1 month.
Whatever.
That
He
will be
deposit.
easier for us to.
That order will be passed, but take the instruction. And be it in writing so that that would be better. On the document itself, in the letter pad or affidavit, whatever instruction from the concerned authority, take it and file it, and if he
Bank is always interested to recover.
Yes,
the
yes.
money.
Yes.
Sorry for being late, my lord. Item 5 permitted to withdraw. So, in the meantime, the player made.
The Land and Council for the item number 5 files a memo for withdrawal of the writ petition on the grounds that the matter has become surplus. Memo is taken on record and the writ petition is disposed for.
Item 8.
Limited prayer with lordship there. The register number, my lord.
2023.
106 of 2023. In fact, it is filed in the year 2020. Lordship kindly have glanced at the order annexer.
No, the other side has already appeared.
Other side already appeared and pleadings are over.
Readings are over. Have you moved any application for expeditious hearing there? Why are you not moving that? We can pass an order. You want an early disposal of that essay. We are permitting you to move an application for early disposal, which should be considered favorably, and that word also we are using. And Mr. Sao, you are appearing for?
In essay, I am appearing.
Essay, you are appearing for whom?
For the Indian version.
For the bank. All right.
Property is
We are mentioning your name.
Melody is present
Yes,
in
yes. This writ petition has been filed by the petitioner, Purnachandra Mahapatra, the prayer for a direction, the Land and DRT Qatar, to dispose of essay number 106 of 2023 within a stipulated period. The Land Council for the petitioner submits that the pleadings are complete and therefore necessary direction may be passed in that respect.
However, it's not requested the DRT.
He fairly submits that no application has been moved before the DRT for early disposal of the essay. Mr. Tuna Sahoo and Council submits that he is appearing for the bank before the DRT, and if any such application is moved for early disposal of the essay, he will cooperate with the Land DRT in that respect. In view of such submission made by the Land Council for the respective parties, the writ petition is disposed of, giving liberty to the petition to file an application before the Land DRT Qatar for early disposal of essay number 106 of 2023. And in case such application is filed within a period of 2 weeks from today, the same shall be considered favorably accordingly the writ petition is disposed of. Yes.
Item 9.
The petitioner challenging the e-auction sale notice, my lord. He has taken loan 73 lakhs and out of which 14 lakhs 60,000 he has paid. Thereafter, he came to know that the self-same property has been mortgaged by another person in another bank manner. Therefore, he did not pay the
low name of my lord. Another person, my lord, this is a flat, my lord. When he has purchased at that time that property from all encumbrance.
So how many decisions are there of this court as well as the Honorable Supreme Court that against this 13-4 notice, the writ is not maintainable because appropriate alternative remedy is available to you? We go to you are appealing to
SA 152 by 2.
Oh, it is already pending.
Before the DRT cutout. Case is
SA number कितने?
11.
SA number
152 by 2024.
17 है भी.
17.
2024 डेट के फिक्स हो गई है
11/7 को issue.
11/7/2025 तब भी से लिखी जाती
जानी
Forums of
this is not
withdraw करो.
my lord.
the Learning Council for the this writ petition has been filed by the petitioners Avinash Kumar Singh and Rosalind Benjamin with a prayer for such answers. The Learning Council, Mr. Puna Sahu, the Learning Council appearing for the opposite party bank submits
Union Bank of India.
Union Bank of
Money.
India submits that the action cell notice dated 11/3/2025 is already under challenge before the London DRT cutter in SA number 152 of 2024 and it is posted to 11/7/2025 in view of such submission made by the London Council for the opposite party, the London Council for the petitioners seeks permission to withdraw the writ petition. Accordingly, the writ petition is disposed of as withdrawn.
That secondly is filed by the bank.
Surface application.
Second
application.
Second appeal no mo seta essay.
Surface application.
Surface application. Second appeal. Yes.
Item 11.
My lord, yesterday, serial number 9, my lord, a similar matter was there, my lords, and your lordship was pleased to post this matter on 23rd 6, your lordship. On the ground that the mediation is going on. 23rd similar matter tila kali, upon the posting ko check.
What is the number of that?
My lord, WPC number.
Please give it in writing, Ladan.
I am appearing for opposite party bank.
Suanshu files a appearance files local of number for the opposite party bank, which is taken on record. It is submitted by the Land Council for the petitioner that identical matter that is WPC number so was listed yesterday.
Yesterday.
And it was adjourned to
23rd 6.
23rd 6 2025 and this matter may be also taken up on that day with WPC. This matter on 23/6/2025 with WPC number so the name of the Land Council for the Orissa Gramya Bank be reflected in the false list here.
My lord, they may directly submit a copy of.
Asha, let a copy of the writ petition be sought on the Land Council for the opposite party in the meantime.
Item 12.
I mean, DC, my lord. The auction sale notice under Annex 1 is under challenge. And Annex 2 is the ROR, where it is mentioned that I am the part owner of the plot. Without giving any notice to the petitioners, they going to auction the property. I am not the loanee, my lord. I am the part owner of that particular property was mortgaged before the bank, my lord.
Mr. Vidya, that date is already over. The date of auction sale was on 2/3/2025. বড় বড় অক্ষরে লেখা আছে ই নিলাম তারিখ ও সময় 12/3/2025 পূর্বাহ্ন 11টা তো কোন হেলা সেদিন
no knowledge, my lord, because I have not intimated, my lord.
So third party right might have been created in view of Vapna's case. This is not maintainable. We are disposing of. Okay. This writ petition has been filed challenging by the petitioner so and so. challenging the e-auction cell notice dated 7/2/2025 under Annexure 1 issued by the opposite parties. On perusal of Annexure 1, it appears that the date of e-auction was fixed to 12/3/2025. The Land Counsel for the petitioner submits that he has no instruction as to what happened on 12/3/2025. In view of the Bapna Motor case, we are of the view that the petition is not maintainable and accordingly.
May I pray, my lord, the liberty can be given to raise for the DRT if so called.
That is always available to you.
Lordship, operation can help me because I have no knowledge. I am the part owner of that plot. Without giving any notice to me, it was.
May seek, all right. The petitioner may seek appropriate remedy in accordance with law. Yes.
My lord, oblige.
Item 13.
In this case, we have only minutes limited there to direct the minutes collector from District Magistrate Jagasambha to dispose of the section 14 petition that's under another 3 minutes.
To take the instructions regarding the status of that.
Yes, sir.
This writ petition has been filed by the petitioner, Chief Manager from Authorized Officer, State Bank of India, with a prayer for disposal of Bank FSI case number 50 of 2023, filed under section 14 of this FSI Act. By the opposite party.
No, one.
So, the Land Counsel for the state seeks some time to obtain the status of the aforesaid case. Put of this matter. Keber rakhiya, madam? 30 तारीख? Start of time. Leave this matter on 30/6/2029. Yeah. Okay.
Item 14.
Madam, pardon, Madam, visible order. That is a matter relating to recovery of debt duty and the way has been expedited allowed by filed by the bank, against which I file application for restitution. And your lordship kindly have a peruse the page number 16 annexure 1 of the order. The application.
Just a minute. Your prayer, please come to your prayer.
Yes.
You allow the same and set aside the dismissal order dated 19/3/2024 under annexure 1 in IA number so and so, and please to set aside acha. So annexure 1, what is that? Let us see.
Annexure 1 starts from the page 14, my lord.
Page 16 is the order.
Yes, that meant.
So you filed this interim application as it appears for condonation of delay in filing the mail for setting aside the ex parte order.
2 years, 6 months.
Yes.
Achha. Now the order has been passed and your IA has been disposed of, and it is held that it is devoid of merit. So this order has been passed, and against this order there is an appeal provision.
All right, my lord, that is appeal provision is section 70 of the DRT Act.
DRT.
Recovery of payment. As like as 19, this is a
just a minute.
20.
Section 19.
19 is the application filed by section 20. Recovery of debt and due to bank.
Please wait. Rise to appellate tribunal. Any person, that is section 18.
No, it's a matter of recovery. Lots of just 2-3 pages thereafter. Section 19 application is filed by the bank of recovery. One is application filed by the surface act by myself. Another is to be filed by the bank. There is 2 acts. sufficient recovery of.
That is regarding the original application.
Yeah.
But against the original application, he is saying original application under the RDDB Act. It is sufficient.
26.
Huh?
Against the order of the presiding officer, appeal can be filed under section 20 of the RTD.
Yes.
20 of the
RTD.
Yes.
recovery of the jail. Yes, appeal to the appellate tribunal.
Yes.
Any
Madam.
person an order made so and so by tribunal may prefer an appeal later.
Yes.
So you oppose it, Lekon.
One thing, well, point of jurisdiction and death certificate. The proceeding has been allowed against a dead person. Two things. Jurisdiction also want to that is why I
Raise all those points. Learned counsel, please raise all those points you are free to raise. Like on the petitioners, so and so, have filed this writ petition with a prayer for sitting aside the order dated 19/3/2024 passed by the Land Debt Recovery Tribunal, but in dismissing the IA number 1269 of 2023 with a further prayer to set aside the ex parte judgment dated 12/2/2021 in way number 331 of 2018 and for remanding the matter to DRT Cutter for fresh hearing of way number 331 of 2018 along with pending essay number 68 of 2021 on merit in accordance with law. The Land Council fairly submits, but again, the interim order dated 19/3/24. There is a provision of appeal under section 20 of the Recovery of Debts and Bankruptcy Act 1993. In view of such submission, this writ petition is disposed of, giving liberty to the petitioner to approach the appellate tribunal in accordance with law. The petition is accordingly disposed of. Yes, next.
Item 15.
So,
in this matter, limited grievances.
that is
Directing to the
readings are complete.
everything are completed.
Come to page 37. You approach the appellate tribunal.
Yes, my lord.
The appellate tribunal has given an observation.
My lord,
Wait.
expeditiously disposal, they have not indicated
That's right.
within the stipulated time. The only loss is
The appellate tribunal says that it is expected that it is disposed of expeditiously.
expeditiously, my lord,
When this-
time may kindly only
When
for-
this order was passed in 2024,
my lord.
thereafter have you moved any application
My lord, we have moved application before the DRT also.
after this order?
After this
After
order.
11/7/2024. This order will page 37, my lord.
Thereafter, no, 37 ପରେ
My lord.
ଆପଣ କୌଣସି ଏଇ order କୁ annex କରିକିନି କୌଣସି application ଦେଇଛନ୍ତି କି?
My lord, I that is the that I
ଏ ବିଷୟରେ
have
କିଛି
not
ଉଲ୍ଲେଖ କରିଛନ୍ତି
annexed
ଆପଣ?
that.
Writ petition ରେ କିଛି ଉଲ୍ଲେଖ କରିଛନ୍ତି?
No, is that things I have not indicated, but
You move an application.
yes, yes, sir. Lordship.
The writ petition has been
Yes.
filed by the petitioners. A limited prayer for a direction to the land DRT for early disposal of essay number 105 of 2023. It appears from the order number 6 dated 11/7/2024, passed by the Debts Recovery Appellate Tribunal at Kolkata, that the Land Tribunal has passed an order that the SA number 105 of 2023 shall be disposed of expeditiously by the Land DRT as per his own roster. Land Council for the petitioner, Mr. Sahoo, fairly submits that after the aforesaid order dated 11/7/2024, he has not moved any application before the Land DRT Contract for early disposal of SA number 105 of 2023, annexing the order dated 11/7/2024 of the Land Debts Recovery Appellate Tribunal, and he may be permitted to move such application, and the Land Tribunal may be directed to consider the same favorably. In view of the limited nature of grievance of the petitioner, his petition is disposed of, giving liberty to the petitioner to file an appropriate application before the Land DRT Cutter for expeditious disposal of the SA numbers 1, so annexing the order
Within a stipulated time frame.
within a stipulated time.
Within a stipulated time frame. Yes, yes.
Stipulated time. If such an application is filed, the same shall be.
Once this matter at page 27 was reached to the stage of judgment, thereafter matter is not that is anyway you yes.
The same shall be considered favorably, and the matter to disposed of at an earliest development. Yes, the petition is disposed of. Next.
Item 16.
Also similar that we.
It is item.
No, DRT is
similar.
The last page. And Annexure 6, page 77.
Same. Next.
Item 17.
May I please action? Also, here the petitioner has very limited grievance. The auction has already been successful. The property has been sold, your lordship. Only grievance is that dates have been passed, no order has been passed in the IA, lordship. Your lordship, no order has been passed in the IA filed by the petitioner, your lordship. Only limited queries.
No IA has been.
No order passed in IA.
And the IA is filed by the petitioner.
Which IA?
In the DRT, your lordship.
Oh. You have already approached the DRT.
Yes, your lordship. Only grievance is to.
So what is your prayer here?
Time bound fees.
Wait, which IA you are talking about?
IA is filed in the DRT.
Which IA? What is the prayer in that IA?
Implementation of the auction purchase.
So please see your prayer, whether in this writ petition there is any such prayer.
Settling the loan amount and all. Where is the IA?
If your prayer is limited, that should have been reflected in the prayer portion. And have you annexed the copy of the interim application to this writ petition, which you want us to direct the Land DRT?
You know, only annex the orders passed in the DRT.
No, the IA which you want expeditious disposal, where is that IA? So was that IA so that.
Have you got a copy of that interim application?
Your lordship, only I have.
Do you have the copy with you now?
No, your lordship, I have awarded in the writ petition.
Where is that averment?
Your lordship, page 5.
Page 5.
Para 8.
Para 8.
Last 5 lines. The petitioner has also filed an IA for implementation.
What is the number of that IA?
601 of 2025.
601 of 2025.
25.
What is the prayer made in that IA?
For implementation of the auction purchaser.
For implementation
Of the auction purchaser.
Implementation of the.
Auction purchaser as in party.
No, we could not follow. Why? You should have filed that IA copy here.
Your lordship, that is not inadvertently not filed.
Here is a matter, my lord, property sold. Sale certificate has been registered before the appropriate forum and ROR has been published in the name of the auction purchase.
He just wants some, that one IA is to that much of order, but just.
He wants that, it is definitely, my lord, without hearing the auction purchaser, court cannot pledge. That is the settled position of law. So he wants that to implement the auction purchaser by which essay can be heard.
Let the application be heard. What is wrong?
I don't have any objection.
Want to
This is the
see-
status I am telling.
One IA is pending, and if we see that IA, we could have mentioned that what is the purpose for which you are filing that IA. That copy is not available. We are listing it tomorrow. You bring that copy of that interim application, right?
You may not file, show us.
Just the learned counsel for the petition. Your name? Rashmi Rekha Pradhan. You have got, yes, Prava. Yes.
For that reason, we don't have any objection.
No, it's all right. We just want to see that IA.
Rashmi
Rashmi Rekha Pradhan, learned counsel for the petitioner, pays for an adjournment till tomorrow. This matter on 19th of June 2025. Yeah.
Item 18.
We may be.
Yes, Mr.
Here, my the essay number 75 of 2021 is pending for the DRT, my lord. The bank is the petitioner for receipt.
Pleading is complete.
Pleadings are complete.
Same prayer for them. You move an application that will be displayed.
Can we have glance to paragraph 6 of the writ petition, where I have averred that IA number
ଆଗରୁ move କରିଥିଲେ
ଆଗରୁ move କରିଥିଲୁ for
ହେଲା ଆଉ ଥରେ ଆମ order ନେଇକି move କରନ୍ତୁ, that will be considered favorably, which we are passing generally order. So same type of protocol. This the prayer is this, and if any interim application IA is moved for early disposal of the forfeit letters, same shall be the commission the pleadings are complete. The same shall be considered favorably, ହେଲା, and it will be disposed of within a time limit, ହେଲା.
You will move application for preponement of date.
Preponement and another.
But now you can do that.
It will be disposed. We are giving you time for 2 weeks to file that interim application. Interim application for expeditious hearing of that essay is to be filed within a period of 2 weeks from today. In the event of which the same shall be done. Yes.
May I submit one thing? No, today, in fact, when the SAG, my lord, before the DRT, I will also go there, my lord.
No, we are just disposing of this observation. If it is taken off today and dispose of matter is all right. If it is not taken off, it is adjourned. You can today also, if the court wants to adjourn the matter, you say that such an order has been passed. Please keep this matter day after tomorrow so that you can produce the order of this court before the DRT for early disposal. Yeah.
Item 19.
The petition number 1 and 2, the borrower and the forward. The loan is already sanctioned on by the and installment has already been.
Speak little louder.
Installment has already been recovered. Let's see the annex of 12, 13, page 13.
What you are challenging here? In this petition, you are challenging the demand notice dated 2/4/2025.
Yes.
Come to that notice.
2/4/2025 issued by the opposite party to the petitioner about recall of loan amounts, termination of loan agreement, and demand for outstanding dues regarding against the loan agreement.
So after receipt of that notice, or this letter under annexure 4, you submitted your representation on 24/4/2025. Had annexure 5.
Oh, yes.
So what response you got from the bank?
And whenever the petitioner went to the bank, ultimately they misuse to them that you do.
Upon in writing, you letter ସେମାନେ ଇସ୍ୟୁ କଲେ ଆପଣ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଲେ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେବା ପରେ ବ୍ୟାଙ୍କ ତରଫରୁ କୌଣସି ଇଣ୍ଟିମେସନ ଆପଣ ପାଇଛନ୍ତି
ନା
କି?
ନା କିଛି ନାହିଁ।
Who is appearing for this endorsed bank? Any idea? Any panel counsel is there? Panel counsel की अछंती किसी idea अच्छी endorsed bank ପାଇଁ ना नहीं? Have you taken any averment in your writ petition that after submission of the representation dated 24/4/2025, no response has been received by the petitioner? You are making a statement before us that annexure 5 you submitted, thereafter you have not received any communication from the bank. We are asking you that whether you have taken any such averment in the writ petition.
Page 9.
Page 9.
Prayer
Page 9.
Prayer upare. Prayer upare. Shati dikshit. Para nahi. Nothing.
This is your oral just submission. 24/4/2025 रे आपण रिप्रेजेंटेशन दबा परे ये रिट पिटिशन केबे फाइल करले?
23/4/25.
ओहो आपण ये रिट पिटिशन टाकू रिप्रेजेंटेशन फाइल करचंती 24/4 रे
गोटे दिन आगु फाइल करचंदी सी आपण रिट पिटिशन केबे फाइल करले? Tell the date. The date which you have written is 23/4/2025. You have filed the writ petition. How could you give a representation on 24/4/2025? तेईस रे फाइल करछंती writ petition देखो ना देठी आपण page 9 पे आसंतु prayer come to the prayer.
नहीं
Come to the prayer. तो आसन date देखो 23/4
बुलकिन बट रिट पिटिशन रे इंडेक्स रेट 29/4 लिखा है 29/4 is but filing date देखुची एठी हमरो स्लीप रे देखुची हाई कोर्ट स्लीप रे फाइलिंग डेट फाइलिंग होची 16/5/2025 सो टाइप पे भी येची फाइल और ना 16/5/2025 रे फाइल करते
आपण 23 तारिख रे रिट पिटिशन बनैले 24 तारिख दिन रिप्रेजेंटेशन देले हां तापर 16 मई मास रे फाइल करचोंदी First you prepare the writ petition. Thereafter you gave a representation. Thereafter you have filed it. When you mentally prepare to file a writ petition, give a representation, prepare the writ petition and file it.
आ पूर्वରୁ ଅନେକ ଥର ଧମକଚମକ କରିଥିଲେ
all ploys
instruction made to
copy दियंतु सब लाइक एडवांस कॉपी इन द
बैंक के पैनल काउंसिल मानती है जानना
getting supply copy to the bank branch.
नोटिस क्या ब्रांच होगा कोई का पुणे रोज मुंबई
ब्रांच
यार ऐसी पूरी ब्रांच कोटा
को ब्रांच है
याजपुर opposite party number 3 opposite party number 3 all right the grievance of the petitioner in this writ petition is that to challenge the demand notice dated 2/4/2025 under annexure 4 with a further prayer for disposal of the representation submitted by the petitioner on 24/4/2025 under annexure 5 regarding the repayment of the outstanding loan amount by one-time settlement. The learning counsel for the petitioner submitted that after receipt of the demand notice on 2/4/2025, the petitioner submitted the representation on 24/4/2025, but no response has been received from the bank, even though the petitioner has specifically indicated in the representation that the loan amount, outstanding loan amount is settled by way of one-time settlement as per the provisions of sub-SIR.
There is no proof for this.
So, no documentary proof that such a representation has been submitted before the branch manager, endorsing branch, Chandigarh branch, that is opposite party number 3. Stop. Let a copy of the writ petition be served on the opposite party number 3 by the petitioners by end of this week. And the matter be listed in the week commencing from 30th of June 2025. If any such representation as stated in the writ petition has been submitted by the petitioners before the opposite party number 3, the opposite party number 3 shall apprise this court on the next date about the status of the representation. The Land Counsel for the petitioner shall produce the documentary evidence relating to service of copy of the writ petition on the opposite party number 3 on that day, on the next date, which is fixed to 30th of June 2025. I don't believe that.
Item 20.
Please, so in item 21, we have instructed to appear for opposite parties. We have instructed to appear for opposite party, let a copy be sought, madam. But that contempt matter. Contempt against the contempt writ is not maintainable. So your lordship, let a copy be sought.
You have instruction to appear for this Amulya Kumar.
My lord, contempt is pending before the Lord Central Landfill Tribunal. Now against that they have filed the case.
It's all right. You file your appearance.
Appearance, let a copy be sought.
When that contempt petition is posted.
Posted on 20th for personal appearance of the DG. 20th.
20th. All right.
But because the Supreme Court has been already on session.
It's all right. We are just keeping this matter to next week.
Yes.
And he will file the wakalatnama in the meantime. We are passing an order that the interim order dated past regarding appearance shall be kept in abeyance till the next day.
Yes, sir.
Right.
Yes, sir.
So, lucky.
My lord, the food sound has been off. Food sound is not coming.
Oh, it is there, it is on.
Oh, sorry,
Mr.
sir. Now it is audible.
Subhani Company?
Ever sir. Ever student. Majuro one.
Okay.
Now you can hear.
Yes.
No, yes, fine.
Yes.
Publish.
So, Mr. Maharana, Land Counsel for the petitioner, Senior Panel Counsel for the petitioner, points out the order dated, which order which shows that
1/5/2025.
order dated 1/5/2025
Annexure 10.
under Annexure 10 passed by Annexure 10.
Yes, madam. In the next sub item 16389.
16 সেটা বার করো 163 points out the order dated 1/5/2025 passed by the London Central Administrative Tribunal Cuttack Bench Cuttack in CP number 260 00017 of 2024, in which direction has been passed to the Director General, Sudarshan Kendra, New Delhi, to appear in person on 26/2025 at 10:50 a.m. Since we are posting this case to 24th of June 2025, the personal appearance of the Director General shall not be insisted upon till next date. Full copy of the order be handed over to the Land Council for the Union of India.
Let a copy be served on read.
Let a copy of the writ petition in both the cases. It has got a common order passed through. In both the writ petition, is sought on the Land Council.
Already served.
Sought in court. Opposite party. You filed your Okalatnama during course of this week. The name of the Land Council be reflected in the cause list henceforth. Okay.
Item 21.
Contracting Council of OSRTC, his mother health condition
Kindly
is
see the order dated 6/2/25. Kindly see the order dated 6/2/25. Order number 28.
That's kindly taken up one.
Just a minute.
Your Lordship is directed to explore the opportunity of amicable settlement.
Yes, we passed the order that the chairman come managing director OSRTC, principal secretary to the government, commerce and transport department, finance secretary to the government of Odisha, shall sit together and make an endeavor to amicably resolve the dispute which has arisen between OSRTC and the 16 retired employees of the corporation in whose favor the order has been passed. So that is what happened. Any
Like, I don't have any instruction by.
No. We have been communicated that proceeding of the meeting. The proceeding of the meeting has been communicated to the respondent. That order is dated 14th May 25.
Very that what happened ultimately.
I thought they have rejected this one that the
Please file what has happened in
that the government has to file that. I will communicated that.
All right. As it's submitted by the London Council that the meeting has already taken place.
Yes.
And some orders have been passed. We just want you to file that order. What happened on all right. So the London Council, you are appearing from whom?
Respondent.
The London respondent number 1.
So one is.
Yes, all.
You are
Comment is you.
I am also appearing.
What of which case?
the learning counsel for the, आपण कहाँ पे appeal करिए?
Government bank, respond number 2.
Respondent number 2. The learning counsel for the petitioners and respondent number 1 submits the petitioner not the appellants for the learning counsel for the appellants and the respondent number 1 submits that as per the order dated 6/2/2025, the meeting has taken place and some decision has been taken. The learning counsel for the state 6 for an adjournment to obtain instruction regarding the compliance of the order dated 6/2/2025 and outcome of the meeting put up this matter. Madam, we'll keep it on 30th.
Can I pay for some more time?
One more week, Acha. Keep it on next week.
First week of July.
It is the 7th July.
I don't know, but we have filed one IA stating that in the meantime, OSRTC has a clear up the dues to the existing staff. We filed a basically flag H, my lord.
27 crores, my lord.
27 crores they have paid.
Our 30 lakhs.
So let him take instruction. We'll consider all things.
Well, that IA, they may take instruction on that IA. Flag H.
What is the number?
My lord, 1583.
158. Acha, 7 of July 2025. An interim application has been filed by IA number 1583 of 2025 by in WA number 170 of 2018 by the respondent of number 1 CORAM.
Yes, ma'am.
In which averment has been made. Which paragraph you say?
That document also available.
Look, what will
Para 8.
Just a minute. Paragraph?
Paragraph 8.
8.
Yes, ma'am.
Paragraph number 8.
Page 4. More than 20 crores have been permitted in the
Acha. In which averment has been taken. That payment has been made to the existing employees to the extent of more than rupees 20 crores. The Land and Council for the states have also obtained specific instruction on this interim application by the next date.
Two and also corporation. Both will take.
OSRTC can
Corporation has
Land Council for the corporation for the OSRTC shall take specific instruction in that respect. State made a OSRTC name. So this matter will come on 7th.
The document I've given that 27 crores, 7 lakhs, 19,470.
20 lakhs averment nahi aayi thi?
Maybe 27, but document we have given more than
It's all right, let them continue.
Obliged.
7/7/2025 with all connected matters. Here? 7 तारीख रहिला आपला?
Item 22.
May I please, Your Honor?
Yes.
That is a case we are not having. The junior time scale officer was directed to work in a junior time scale post. So whether he is entitled to get the benefit, that is your lawsuit, Naveen Sena, Union of India versus Naveen Sena case.
Who is appealing for the other side?
Union
My
of
lord, we are
India.
appearing, my lord. The postal department, the crux of the issue is that petitioner was working 4 years, not less than 4 years.
Mr. Pari, he said that in another matter, similar matter, an order has been passed. So please examine the decision which he is giving. And
My lord, friend may refer the number and all these things. I will check it up.
no, any of your counsel is present, he can hand it. He is present. So
Yes, sir.
the copy
please hand over a copy.
Mr. Aiguru can carry this, yes.
Covered under this case or not? Just
Yes.
Learning Council for the petitioner has filed the order dated 17/4/2025. Passed in WPC number 5178 of 2025 in the case of Union of India and another versus Naveen Kumar Senapati, and submits that this case is covered in the by the aforesaid order dated 17/4/2025. A copy of the order has been handed over to the Land Council for the Union of India, who seeks some time to verify the same. Put up this, Mr. Pari, whether it will be taken off on Monday 23rd or it will be on 30th.
10 days time.
You are just to examine this order.
2-3 pages order.
Yes, my lord, but simultaneously I also ask the officials whether any. Because there is a direction from the CAT that within 120 days they have to dispose of the same by passing on the Supreme Court judgment. Whether they have passed it.
30th of June 2025. The order is taken on record for you, huh?
Item 25.
Mr. Danan Mahapatro.
May I please, Your Lordship?
Yeah.
Your Lordship, I'm appearing on behalf of Danan Mahapatra, sir. Your Lordship, we have filed the rejoinder today. It has not come in the record yet. Your Lordship, the commission has not
yet. Is appearing for the other side, the opposite party?
I am appearing for OP number 3, my lords.
Okay. Have you received a copy of the rejoinder?
No, my lord.
So serve a copy on the Land and Council. You serve a copy on all the opposite parties. The council for Mr. SP Mishra is appearing for opposite party number 4, I think. And for 2 and 3, the names of Mr. L. Mahapatra is there.
My lords, only 3, my lords. Only 3.
3, acha. All right.
Because the 1 and 2 are the adjudicating bodies.
All right. Madam, what is your good name?
A. Mishra, Amrita Mishra, Your Lordship.
Amrita Mishra, Land Council appearing for the senior advocate, Mr. Danan Mahapatra, submits that rejoinder affidavit has already been filed today. However, the copy of the rejoinder has not been served on the Land and Council for the opposite parties, and the same will be served during course of this week. Land Council for the opposite parties that present put up this matter in the week commencing from 30th of June 2025. The rejoinder affidavit we placed on the post. So, right?
There for the opposite party number 4.
Please give the name if you want to mention the name. Please mention. So and so is present for opposite party number so and so.
Obliged. Item 26.
May I please, my lord, I am for the auction purchaser. Pursuant to the order of the Honorable Court, my lord's police assistant was given for recovery of the auction property for possession from the encroachers, and despite all effort, we were unable to take the possession of the entire property. Only a partial of the auction property was.
Transported to copy to madam. We are keeping it to tomorrow.
Yes, I'll
You will
serve
serve a copy so that let him go through it.
Have you recovered the possession and given it or not?
Partial.
See that before there is a partial, the occupants of that place, they undertook that they will vacate the place by a particular date. And the bank has recorded his satisfaction, Your Lordship.
Particular day proof the wicket line. When, but which date? Which particular date you are talking about?
25 to
25? 25 2 is already.
Purchase দুই তো পড়ে নানি they agreed to vacate আমি লিখেছি they agreed to vacate on 25 to
The letter is
2025
on 28 to 20th February.
That's all right. Now what is the position? Have they vacated?
That
Get
is
the
not-
instruction.
not-
get the instruction
Get the instruction.
you serve a copy
Yes.
and also
Right.
get the instruction about the present status
Yes.
right
Yes, sir.
and so that we are giving you some more time so
Yes.
let us
Just see
the
the
learning council for the
If maybe pardon me, so what I beg to submit is that unless there is apprehension of threat to life also, because while taking possession, there was a threat.
position
And,
you are giving
Yes.
the চিঠি
That's their outlook. They have to give you physical position. You.
বর্তমান এই চিঠিটা হচ্ছে ফেব্রুয়ারি মাসের
ଆଜ୍ଞା ଆଜ୍ଞା
so in the meantime
ଏତେ
3
କଷ୍ଟ
months
ପୋଜିସନ ଟା ନବାକୁ ମୁଁ ମାନେ ବେଟର ଆଇ will opt for return of the money with interest.
just a minute.
Return of money, we have not have any objection.
କାହିଁକିନା ସେଠି ଏତେ apprehension of
It's
life
all right.
threat.
This is just a minute. Let me do. The Learning Council for the state has produced the written instruction dated 28 to 2025 received from Deputy Commissioner of Police, Cuttack, in which it is mentioned that
May I read the?
the
The present
occupant
occupants also resisting to vacate the mortgage property after
the
disposal.
occupants were resisting to vacate the mortgage property
After
and after discussion, they agreed to vacate the premises fully on or before 25 to 2025. Stop. It is further stated that partial possession was handed over to the authorized officer and time was given to the occupants to vacate the premises fully by 25 to 2025. Stop. The Learning Council for the petitioner submits that till date, the occupants have not vacated the mortgage property, the position of the mortgage property. The Learning Council for the state seeks some more time to obtain the status of the vacation of the mortgage property and handing over the possession fully to the petitioner. List this matter on 30th of June 2025. A copy of the letter dated 28 to 2025 has been handed over to the Learning Council for the petitioner. So also, lekhi douchu apon dei debe. So also the Learning Council for the bank, right?
Yes.
It will be given to you. This is taken on record.
Let the police do the work. You don't go there. If you go, there is a threat. Why are you going?
ତାଙ୍କୁ ବିଦା କରି ସାରିଲା ପରେ
ଆଜ୍ଞା,
ଆପଣ ଦେଇଦେବେ
ଆଜ୍ଞା,
ଆଉ।
ଆଜ୍ଞା।
ସେଠି ଗଲେ ସିନା କିଛି ବାସ୍ ନେକ୍ସଟ
Item 27.
27, my lord, I am appearing for the petitioner. But in this case, I will file a short rejoinder kindly taken up on 44. My lord, Senior has
Okay.
objected appearance and I will counter. I will file a short rejoinder.
The Learning Council for the Union of India now submits that he has received the copy of the counter affidavit filed by the opposite party number 1 and he intends to file a rejoinder affidavit and the matter may be taken out
On 44.
next week. List this matter on 24/6/2025.
Okay.
Rejoinder affidavit, if any, be filed in the meantime, serving a copy on the Learning Council for the opposite party. Yes.
May I prevail? This matter neither admitted nor notice issued in this case. So this matter may come on 24th under the heading press admission fee.
ପଢୁଛି ତ ଆପଣଙ୍କର କଣ ଏମିତି ଅସୁବିଧା କଣ ହେଲା? ଆଜି ତ 12ଟା ବେଳେ ପଡିଲା ଆଉ ହଇରାଣ କଣ ଆଡମିସନ ଆସିଲେ ଫ୍ରେଶ ଆଡମିସନ ଆଇଲେ ପଡିବ ଏଥିରେ ପଡିବନି ଏମିତି ତ କିଛି ନାହିଁ ହେଲା ତ 24 ତାରିଖ ଆସୁଛି 24/6/2025. Yes.
That may be reflected in the court.
Yes. Wakalatnama. Yes. The name of the Learning Council be reflected in the cause. Wakalatnama drop on. Yes.
Item 28.
Item 28, where the petitioner And
Yes.
I seek 10 days time, my lord, because the concerned council is changed. Now, Mr. Rao.
You have received the counter
No,
affidavit,
we have
Mr.
the
Pari?
petitioner here. The Union of India challenges.
No, that is correct. Counter affidavit has been filed by the sole opposite party, that is the noting in the cause list.
No,
We are
ma'am.
asking you, have you received the copy?
Counter, yes, counter is.
Okay. So, we are adjourning the matter. If you want to file any rejoinder, you can file in the meantime.
2 weeks time, Lakshmi.
All right. You are for the opposition.
There is nothing to be adjudicated because this writ petition is filed for second time. Earlier, this court was pleased to allow the prayer only because the Royal Tribunal keep the matter reserved more than 6 months.
On remand, this order has been passed. Matter to examine.
The Land Counsel for the Mr. Pari, Land and Deputy Solicitor General submits 6 for an adjournment and further submit that he has received the copy of the counter affidavit filed by the opposite party and you will file the rejoinder affidavit in the meantime. Is this matter on 30th of June 2025?
Yes, ma'am. Yes.
Okay.
Item 29.
But instead of 30 June, can it be first week of July?
All right. Next week, 7/7/2025. It is the next week. Yeah.
In this case, my lord, I am appealing for the petitioner, ma'am. May I pray, my lord, the lordship kindly give a glance the impugn order. Annex 20, page 59.
Who is appearing for the other?
My lord.
Impugn order?
Page 20, page 59, Annex 20. The Lona Tribunal has quoted my prayer made in the original application to the Lona Tribunal, but neither rejected the same nor allowed the same. But passed an order to grant some benefit, which benefit I have already extended since 2016.
Who is allowed
with the direction to grant a benefit.
You are appealing for
compensation.
Behera.
Okay.
So, in the end, it is mentioned that who is allowed to the extent as ever. So, your entire prayer has not been allowed.
My prayer, total prayer, my lord, neither rejected nor allowed, my lord. The prayer, the relief granted to me to grant me the excessive pension that I am getting under Rule 64, my lord.
Speaking order, honest in the eye of law, to quash the memorandum dated so and so. Direct the respondent to grant family pension and release all the death cum superannuation financial benefits of the deceased employee and pass such other. What relief was granted to you? He said that it is allowed. In view of the, come to page number 66. In view of the specific government of the respondents in the counter, the respondents are directed to pay the applicant the financial benefits arising out from the order dated so and so passed by the disciplinary authority modifying the punishment order, that is 2/3 of the compassionate allowance and DCRG, along with the arrears as due within a period of 90 days from the date of receipt of the copy of this order. So obviously the other prayer was not accepted.
The husband of the present petitioner was serving as a gang.
How was it?
Employee of the railway matter.
Yes.
And he was charged with gross misconduct. And punishment, order of punishment was imposed.
And he filed an appeal. Appeal was dismissed.
Appeal, he has never referred an appeal. He has, after receipt of the notice of punishment, second so called, he has, instead of filing his defense, he has stated that mercy petition of appeal. But that is cannot be treated as an appeal.
That was dismissed and giving a liberty to file appeal.
No. Thereafter, punishment order was passed by the competent authority. Thereafter, he did not prefer appeal. And in the meantime, after expiry of 3 to 4 months, he expired. That means the order of punishment remains as it is.
Page 64.
Yes, ma'am, that was the representation.
Just a minute.
Page 60.
That is not. Now, kindly have a glance to.
1 minute.
I'm going there.
64. 64.
There must be appeal deed.
Yes, ma'am. Just before that,
One.
the second sloka is
Then come to paragraph.
next short. I'll kindly have a glance to page 21.
Yeah, just a minute.
One.
Just a minute. Well,
Order
please, read out the paragraph number 8.
8.
Page number 65, internal page is 7.
65. Yes.
The
The order dated
Ah,
28/4/2010 was received by the husband of the applicant on 28/4/2010, and as per instruction, he had to file appeal, if any, within 45 days. That is, within 26th June 2010. The husband of the applicant did not file an appeal and subsequently expired on 11/7/2010. The said punishment notice has attended finally. The stand of the Learned Counsel for the applicant that the order dated 28/4/2010 was a punishment notice and not punishment order is not acceptable, since the said order, the disciplinary authority had clearly stated he is imposing punishment.
Yes.
That is not right.
Punishment of removal from service.
Kindly have a glance to.
Now read it.
Yes, ma'am. Punishment. Further, the letter dated 2/9/2010 and 25/7/2012 are internal communication within the respondent department for settlement of dues on the late employee. Therefore, the tribunal does not find any merit in interfering with the impugned orders, ma'am. This is para 8.
read out next part.
However, it is seen from records that the applicant had filed her application dated 30/3/2015 before the respondent number 1 and paid for converting the order of punishment of removal from service to compulsory retirement from service and grant her consequential financial benefits. Respondent number 1, while his letter dated 25/11/2016, while disposing of her representation, had remitted back the matter to the disciplinary authority to consider the grant of compensate allowance in terms of Rule 65(1) of the Railway Service Pension Rule 993 and RB number such and such. The respondent in their counter at para 2E have taken a specific stand that accordingly the disciplinary authority had modified the punishment order, that is removal from railway service, with 2/3 of compensate allowance and discharge by the order dated 25/11/2016. In view of the specific averment of the respondent in the counter, respondents are directed to pay the applicant the financial benefit arising out of the order dated 25/11/2016 passed by the disciplinary authority, modifying the punishment order, that is 2/3 of the compensate allowance and discharge, along with arrears due within a period of 90 days from the date of receipt of the copy of this order. In view of the discussion made above, the way is allowed to the extent as above, parties to bear their own cost.
What he says that he had some other prayers, and the Learned Tribunal has not discussed whether the
He
petitioner.
has prayed before the Learned Tribunal to quash the memorandum of charge and punishment
He
order.
has got 3 prayers, specific prayers. The Learned Tribunal has not discussed or mentioned anywhere that this petitioner is not entitled to get those reliefs. But he has stated that he is only giving this particular relief. That is why his submission is that neither it is as my prayer is allowed nor it is rejected, but some other relief has been granted which I have not prayed for.
Yes, sir. In reply to my brother's prayer, my lord, when an employee removes from service or dismissed from service, he will not get his service benefits, my lord. But that has been converted to compulsory retirement, for which he was.
Mr. Counsel, the X is making a specific prayer that I am entitled to get this relief, right? So if after the hearing, the tribunal thinks that he is not entitled to get that relief, he has to assign the reasons and pass a specific order that in view of this foregoing discussions,
The wife of the deceased employee, she has made application in 30/3/2015. That is after 5 years husband, which is we have taken a ground before the tribunal. That is a bad by limitation.
discussion ही नहीं
And 65(1) of the pension rules.
Mr. Counsel ଜଣେ ଲୋକ ମାଗୁଛି ଯେ ମତେ 100 ଟଙ୍କା ଦିଅ,
Family pension ରେ ସେ claim
ସେ ଆପଣ discussion judgment ରେ କରିବେ ସେ 100 ଟଙ୍କା ପାଇଁ ହକଦାର କି ନାହିଁ, ମିଳିବ କି ନାହିଁ, ଆପଣ କିଛି discussion କରିବେ ନାହିଁ, ଆପଣ କହିବେ ଗୋଟେ ବହିଟା ନେଇଯା, like that। ତାର prayer ହଉଛି ମତେ 100 ଟଙ୍କା ଦିଅ, ଆପଣ discussion judgment ରେ ଯେତେବେଳେ discussion କରିବେ ତାକୁ କହିବେ ଯେ ଏଇ circumstance ଅନୁଯାୟୀ ସେ 100 ଟଙ୍କା ପାଇବାକୁ ହକଦାର ନୁହେଁ, however he is entitled to get this। ସେ ବିଷୟରେ ତାର ପ୍ରେୟାର 3ଟା ଥିଲା, ସେ ବିଷୟରେ ଟୋଟାଲ ଡିସ୍କସନ ହିଁ ନାହିଁ ଯେ କଣ ପାଇଁ ସେ ଏଣ୍ଟାଇଟଲମେଣ୍ଟ ନୁହେଁ।
Did you follow what following from the court? See, so insofar as the family pension is concerned, there is no discussion at all. That's what his grievance is. There are three prayers basically. 4th prayer is common prayer. The first 2 prayer has been taken care of, no problem. But insofar as the prayer number C is concerned, there is no discussion at all. That is the grievance he has.
That was dealt by the railway authority, appellate authority also.
That the court, the tribunal should have dealt with that and said that yes, it has been already been done, I will not do it. Where is the discussion?
What he wants that this matter be remanded for fresh adjudication to consider whether the petitioner is entitled to get that relief or not. If he say after discussion that it is not entitled, it's all right.
Notice on question of admission.
It is coming for the final disposal, sir.
Notice.
No, he is not under this heading.
File a short reply.
All right. The writ petition has been filed by the petitioner, Junu Behera, with a prayer to quash the order dated 30/4/2024, passed by the Land and Central Administrative Tribunal, Cutter against Cutter, in area number 960 of 2016, under annexure 20 to?
Again,
Annexure 20. The Land and Counsel for the petitioner points out from the infant judgment regarding the prayer that was made by the petitioner in the original application, which is quoted in paragraph number 1 of the infant judgment. The Land and Counsel submit that neither the Land Tribunal has discussed anything whether the petitioner is entitled to get such relief or not, nor rejected the prayer, but has given some other relief which has not been prayed for by the petitioner. The Land Counsel further submits that since there is no reason regarding the entitlement of the petitioner to get these benefits as prayed for, it is a fit case where the matter should be remanded to the Land and Central Administrative Tribunal, Cuttack Bench, for fresh adjudication in accordance with law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Mr. Bhavani Shankar Raiguru has already entered appearance opposite party.
Senior panel counsel. Senior panel counsel.
Senior panel counsel for all the opposite parties. And 6, how much time you want to file the counter affidavit?
3 weeks.
3 weeks time to file the counter affidavit. List this matter 2 weeks for the counter affidavit, if any, be filed in the meantime, serving a copy on the land counsel for the petitioner. Yes.
Item 30.
And you give an extra copy of the writ petition to the land counsel. Yes.
I have already.
Okay.
I have already given.
Okay. Continue, sir.
Item 30.
Item 30, madam. I'm appearing for the applicant.
Yes.
As per the order of the Honorable Court, I have extended to the.
Yes, Mr. Pari, you have
Item
received
30, we need some more time to file counters. Last occasion I sequenced this.
Mr. Pari, Land Counsel, and Deputy Solicitor General submits that he has already received the copies of the writ petition from the Land Counsel for the petitioner and seeks some further time to file the counter affidavit. What time you want, Mr. Pari?
3 weeks time.
3 weeks time. Place this matter on such and such that is. Any other urgent matter? Nahi ho kichhi?
Pardon to mention also.
I for bail. 7 weeks in process.
I have for that.
The bail application, it was directed to listed on 5th of May, but it has not been come.
Yes, got pretty clear.
Supplemental list. Item number 1.
Wish to argue the matter. This is my asking for the best one. Nothing.
So,
Yes, ma'am.
Land Advocate General is present.
My letter, Mr. I am the.
You have been interested. Okay. So, criminal appeal term. Prakash Behra. Nothing. आमे जहाँ कहूँ आपण शुणी पार्छन तो बड़ पाटे कहतु साउंड बटन शुणी पार्छन आपण आपण जो 2 जन एडिशनल सेशन जज आठ मल्लिक कोर्ट रे सीटीएस नंबर 16 2018 मसीहा केस रे आपण जो विचार रो सम्मुखीन होइथिले एवं ताधीरे आपण को 302 दफारे आपण को जो फांसी दंडादेश दिया इतला तार सुनानी आज आरंभ हबो सेथिपाई ए व्यवस्था कराइछि जे आपण मानकर जो सुनानी हबो आपण देखि परिवे एवं एडवोकेट बाबू अछंती व्हाट इज द नेम ऑफ योर काउंसिल हाँ दिलीप कुमार दास अच्छा तो ये सुनानी विषय जहा चली थी सी आपन को बुझेबे एवं जहा आपण मध्य आपनकर वकील को जदि किछि इंस्ट्रक्शन दबा को चाहिए कहवा को चाहिए से विषय मध्य वकील बाबू जनइले से आपनकर जे वकील बाबू छिड़ाई एठी तांको मध्य पास ऑन करि दिन आपण सत्यरंजन मूलिया आपनकर एडवोकेट अछंती से ही मैटर आर्गुमेंट करिवे देखि परछन तो आपण किछि कहिवार अछि कि आपण नहीं आपण आपण वकील बाबू देइथिले रमेश चंद्र महाराणा को वकील देइथिले मुझे कहूची शुणी पार्छंती ना नहीं आपण जो केस टी फाइल करथिले जो फांसी आदेश विषय रे ता नंबर होची 1166 ऑफ 2024 तेत्रे दुई जण एडवोकेट आपण को पई केस दाखल करथिले जांग ना होची रमेश चंद्र महाराणा आउ एके महाराणा हु इज द काउंसिल रमेश चंद्र यू आर द रमेश चंद्र महाराणा तो वर्तमान रमेश चंद्र महाराणा ऑथराइज करुचंती बा देई देइचंती केस को सत्यरंजन मूलिया ऐसा मूलिया को से अछंती एठी छिड़ाइचंती से आपन को केस आर्गुमेंट करिवे आपन को किछि कहिवार अछि कि हां कहिवार अछि कोन कोंतु
सर मु आत्मलिखिरा जज को सर पुडिया थर कहली विजिटिंग रे 17 थर आ कोर्ट रे 3 थर सर कहली जे मु सर निर्दोष आ मते सर एकरा फसाई देती थाना वाला सर जे आकु जे ताकु सर छाडी दी जे बाबला ना एबो बोली जे ताकु सर छाडी दी वाला टंका नहीं ना मु सर ए कथा बार बार कोर्ट रे कहली सर मो कथा के रिसीव करे ए आत्मलिख कोर्ट भी सर मते रिसीव करलेनी किछि सर मो कथा सुना गला नहीं जे तू मते सर निर्दोष रे जे फसाई दिया है ये निर्दोषी सर
नहीं नहीं सुनतु मु से विषय आपन को केस विषय रे पचारुनी केस आपनकर साक्षी प्रमाण हेई सारलानी से तारी ऊपर वर्तमान विचार हबो आपण ए जो एडवोकेट को एंगेज करिथिले रमेश चंद्र महाराणा मध्य उपस्थित अछंती एवं से मूलिया बाबू को तेरंजन मूलिया को आपण को केस एठी आर्गुमेंट आरंभ आजिठू तो ए वकील नियुक्ति बाबद रे आपण किछि आउ किछि कहिबा को चाहुचंती ना आपनकर एसआर मूलिया कोठू आपण हमें ए केस रो जो आर्गुमेंट सुनिबू वकील नियुक्ति विषय आपनकर किछि कहिबार अछि कि आउ
नहीं सर नहीं
ठीक अछि so yeah what is the name of Devashish Tripathi additional Devashish Tripathi please give the names that correct not reflect of so the what we say that we'll proceed with it but what we used to do in जो चैरिटा डेथ रेफरेंस केस जोड़ा कि मु डिवीजन बेंच रे रही जजमेंट प्रोनाउंस करछि सुप्रीम कोर्ट करो जजमेंट देखिछुलु यादरे जहाँ में देखुछु जे if you come to the judgment you will find that the judgment was delivered on 27/9/2024 and come to the first paragraph of the judgment. You'll find that emane tanku 49, 363, 364, 394, 201 by 34 IPC, 25 or 27 Arms Act. Ithre tanku charge premela. Ebong if we'll come to the page number 26 of the judgment, internal page 26. Paragraph number 11. File. So you'll find that the prosecution has proved the case under section 302, 364, 201 by 34 against the accused persons beyond all reasonable doubt. And the accused persons are found not guilty under section 363, 394, 34 IPC and 25, 27 Arms Act. Acha, there is no discussion in this judgment about the charge under section 449 IPC, right? 449 ne taku conviction hella ki acquittal hella e bisar kichi nahi. That's a different matter. But now what you will find that the very day on which announced, that is on 27/9/2024, on the same day, on the question of sentence, there was a hearing, and on the very day, the sentence was passed, right? What the Honorable Supreme Court has held, there is a suo motu writ petition, CRL number 1 of 2022, and that was a 3-judge bench. They just regarding framing of guidelines regarding potential mitigating circumstance to be considered while imposing the death sentences. So Tadre, a matter ultimately larger bench could refer it, but the paragraphs which are relevant, it reads like this, that if you want to sentence somebody for death sentence, what you are to require to do, they have taken into account the ratio laid down in the case of Manoj Pratap Singh versus Manoj and others versus State of Madhya Pradesh. There it has been mentioned, it reports from the probation officer, jail authorities, a trained psychiatrist and psychologist is to assist the accused in presenting the mitigating circumstances. And there is a necessity that there should be a separate hearing and necessity of backgrounds analysis of the accused is to be also highlighted. And it was suggested that social milieu, the age, educational level, whether the convict had faced trauma earlier in life, family circumstances, psychological evaluation of a convict, post-conviction conduct, These are all relevant factors, and it is to be considered whether the death penalty ought to be imposed upon the accused or not. Merely because on the date of pronouncing the judgment, the sentence was passed, that is not the ground to set aside that part. But what the court is required to do, that while imposing the death sentence, all these factors are to be taken into account. But as we find that in this judgment which has been pronounced by the London Trial Court, there is no such aspect was taken in. So what we did in those 4 death reference cases, we passed the order, and the orders, the operative part, we are just placing from one of the cases, being satisfied that the trial court not to have heard hearing on the question of sentence with respect to the appellants in the manner it was expected to, envisages with aggravating and mitigating circumstances to be either on record or with such further opportunity to furnish necessary information or data thereon, the court is of the humble view that before considering the appeals on merit and irrespective of its outcome, in view of the settled position of law, as discussed herein before, for a purposeful and meaningful hearing sentence, the appellant should be afforded an opportunity at present, inviting from them such data to be furnished in the shape of affidavits, and also to direct the jail authority to do the needful in that regard. The court is hence of the view that there is a need for a direction to the, here it will be also the superintendent, it is from on-good jail, na? So the superintendent on-good jail, is it senior superintendent or simply superintendent? On-good jail, it senior superintendent or simple superintendent?
Senior superintendent, sir.
Senior superintendent. So whether it is a circle jail or simple jail?
Circle jail.
Circle jail. Circle jail and on-good. All right. Okay. To collect all such information on the past life of the convicts, this is most important, psychological condition of and also their conduct post-conviction, obtaining reports accordingly by taking service and necessary assistance from the probation officer and such other officers, including a psychologist or a jail doctor or any medical officer attending the prison. Such an exercise is considered to be absolutely expedient in order to advance the cause of justice, intent and purpose being to provide a fair amount of opportunity for the appellants to bring on record all such mitigating circumstances, to the aggravating circumstances, since a balance is to be struck while taking a final decision on the sentence in juxtaposition to the sentences imposed by the trial court. Then what we ordered, that the matter is to be listed on such and such date for that purpose, and the appellant shall submit all such materials on mitigating circumstances by filing affidavits stating therein the particulars for consideration of the court. It is directed that the senior superintendent here and the circle jail will remain. This should be on good, shall exercise his good office and ensure collection of detailed information with reports on the past life, psychological condition, post-conviction conduct of the appellants, and such other matters to be relevant at the final hearing by taking able assistance of the officials concerned. It is further directed that all those materials shall reach this court well before the next date. So we have mentioned in the last that it is clarified that this court has not expressed anything on merits of the appeal, as the appellant should not prejudge and be on any such apprehension for the above exercise being undertaken, which is in relation to the sentencing aspect to be examined finally, while disposing of the death reference. Right? So a free copy we have stated. So if we find that it is a case of acquittal, matter ends there. If we find that there is something for which the conviction is to be confirmed, then so far as the sentence is concerned, definitely both of you will be given opportunity of hearing, and at that time all these things are to be considered. So what the state is required to do, we have indicated that he has to call for all these reports. What you are to do, you are to file by way of an affidavit, separate affidavit, highlighting whatever you want to say, family background, age, no antecedent, whatever you want to say that about your avocation, everything is affidavit debe. But they should not prejudge that we are that we have taken any view against them. So in case it is found it is necessary, then these things obviously are due. So this is just to cut the time, because if we will pass this order after hearing the criminal appeals or death reference on merit, then it will again linger the matter. We have to wait. Let simultaneously the hearing goes on, okay, and let the reports be also obtained in the meantime. So this should be the order, and a copy will be handed over to both of you so far as the sentence part is concerned. Because as we find, if we will come to the question of sentence, hearing on the question of sentence, you will find that Mr. Mulia, please come to the sentence. Just read it out.
Learned counsel for the convict stated to take lenient view while awarding sentence to the convict, as he is the first time offender. The accused Babuli alias Prakash is about 45 years. The accused Ranja alias Nandakishore Sethi is aged about 37 years. He also submitted not to impose the extreme penalty of death on the ground that it is not a rarest of rare case. On the other hand, learned PP asked for harsh punishment, convict as it would make a person like-minded to think before committing such type of offense. On the other hand, this is a triple murder case which comes under the purview of arrest of rare case, and accordingly, the death sentence is the only punishment which will justify the magnitude of offense committed by the accused.
In yes court Machi Singh's case, so eta kaun hai ki na only contention that was raised by the learned counsel for the accused persons in trial that a boyos hochi 45 ବର୍ଷ ବାବୁଲିର ସେ ଗୋଟେ married person ଆଉ ନନ୍ଦକିଶୋର ସେଠୀର ବୟସ ହଉଛି 37 ବର୍ଷ ତେଣୁ ଏଇଟା ଗୋଟେ rarest of rare case ନୁହେଁ ତେଣୁ ଆଧିରେ फांसी दंड न दियाଯାଉ submission hela on behalf of the state that it out a triple case, and then in view of the magnitude of the offense there should be what the Honorable Supreme Court has stated, that this information should be obtained like reports on the past life, psychological condition, post conviction conduct. Of course it is not the thing which could have been, and all other materials. So ei jinso gudako adire total ignore kar diya jaisi ba se jinso ko nazar hi nahi. So that is why we are giving this opportunity to both of you to obtain this report and also you file the affidavit. Now you understand? Okay. So, आपण ए विषय आपण दी जन को टिके कही रखे जे आज जो सुनानी पूर्व आमे गोटे ऑर्डर पास करूछु एवं मेरिट रे तो आपनकर केस विचार हो बाकी जो फांसी आदेश जो हेइची ता ऊपर यदि आपनकर किछि कहिबार थाए आपनकर परिवार विषय आपनकर पूर्व कौन आपण करूथिले फैमिली रे परिवार रे किए सब अछंती ए सब विषय रे बा जहा आपनकर सपक्ष रे थिबो ए सब विषय रे यदि कहिबा को चाहंती आपण गोटे सत्यपाठ जरिया रे आपनकर एडवोकेट जरिया रे दाखल कर देबे एटा संगे रे मेरिट रो किछि संपर्क नाही एटा सुप्रीम कोर्ट करो जो नजीर रहुची ए टाइप रो केस रे आमे गोटे एफिडेविट आम दरकार आपनकर आपण माने देबे चाहिए बाकी सरकारी वकील को कुहाइची से मध्य जहा जहा आपनकर परिवार रो बैकग्राउंड आपनकर इनकम आपनकर मेडिकल रिपोर्ट अन्य जिनस से सब मध्य से ताकू आनिबे आनिकिनी कोर्ट रे दाखल हबो एटा होची जदी फांसी बाकी आज जो मेरिट रे सुनानी हबो केस रे से विषय रे आपण माने सुनंतु आपण वकील बाबू जहाँ भी कहिबे एठी इंग्लिश रे आपण जदी न बुझी परिबे आपनकर वकील बाबू अछंती आपण को बुझेइबे एवं जहाँ भी आपण चाहुचंती आपनकर वकील को किछि कहिबा पई बा केस विषय रे किछि गुरुत्वपूर्ण दबा पई इंस्ट्रक्शन से विषय रे आपण वकील बाबू कहले से एठी जो वकील बाबू आर्गुमेंट करछंती तांको कहि देबे बुझी पाले तो आपण माने दी जण तीन जण जाक बसिकिनी हियरिंग बर्तमान सुनंतु से बाबू की अछंती तांको चेयर रे बसिबा को दियंतु से माने बसिकिनी सुनंतु केडी क्लियरली आर्गुमेंट सुनिबे हला हां ठीक है लेकिन इटा the condemned prisoners sworn so appear through virtual mode and Mr. Dilip Kumar Das. You are the state counsel, Mr. Das? Not पूछेंगे ऐसे माइक लगा तो ये ऑन द स्टून लीगल एड you are the legal aid counsel अच्छा the legal aid counsel is also present to assist the condemned prisoners to understand the proceedings of this court. Stop. Mr. Satyaranjan Mulia, Land Counsel, files the appearance memo for the appellants, which is taken on record. है ना? तापरे जो ऑर्डर था जो हम कहीं से तब पास हो, है ना? Then he has to argue the matter. So, what is the Mulia, you can start. Give me the paper books. Yes. Just a minute. Yeah. तो त्रिपाठी आपनकर देले कि नाटा लिखी ना चीज हाँ please proceed.
FIR was 8/14, my number.
Yes.
FIR was
Page. What is the page number of the paper book?
13 to 16.
Which paper book number 1 or 1 2?
Volume 1, page 15.
Volume 1.
Volume 1.
Volume 1, page number?
Page number 13 to 16.
Yes, please.
FIR lodged by one Sushant Naik against Arnold. May I read the FIR?
Just a minute. Sushant Naik.
Yes.
You come to the FIR.
Manani,
That is page number 15.
page number 51.
Sushant Naik is PW?
PW9.
PW9.
I read the FIR.
PW9 Sushant Naik. Yes. Hold on.
माननीय श्रीयुक्त किशोर नगर थाना भारप्राप्त अधिकारी महोदय महाशय जणाइबार कारण एही कि जे सुशांत नायक
मिस्टर मोलिया टिके रुन आपनकर एडवोकेट जो सुभा जाउची तो अरे कि अनम्यूट कर दला ना कौन
तो पूछे
हाँ ठीक
रिपोर्ट जल्दी
हाँ ठीक नाउ इट्स प्लीज प्रोसीड मिस्टर कुमार
माननीय श्रीयुक्त किशोर नगर थाना भारप्राप्त अधिकारी महोदय महाशय जणाइबार कारण एही कि जे श्री सुशांत नायक बयस 28 पिता गणेश्वर नायक ग्राम गंभारी पोस्ट नगर जिला अनुगुण स्थायी बासिंदा अटे ता 9/10/2017 तारीख में भाई भाउज पुतुरा रात्रि 8 घंटा समय घरे थिले 10/10/2017 मंगलवार सकाल 8 घंटा समय अकस्मात मु देखली मोर भाउज गला कटा हो मृत्यु अवस्था पड़ी किंतु मोर भाई और पुतुरा सन्धान मिलूना तेणु यह तदंत कर दोषी को दंड
So this FIR was lodged against unknown person. Okay, then what happened?
Then during investigation, these present appellants were arrested on basis suspicion, and the statement was recorded under section 27 evidence and a portrait was recovered in the instance of appellant numbers 1 now.
And yes, just a minute. Where is the appeal memo?
Memo.
Just a minute.
Page 69 to 389.
19, page 19.
No, page
appeal memo,
page 69.
paper book, second paper book रे अछि.
Volume 2.
हाँ. Volume 2 रे page 369.
369.
अच्छा, just a minute. Right. So, No, it is a case based on circumstantial evidence. So, FIR was lodged against unknown persons. During course of investigation, both the appellants were taken into custody. And you say that at the instance of this appellant number 1, means Prakash Behra, what was recovered?
Patari was recovered. Patari.
Achha.
MO6.
Patari, MO6. Anything else?
There is also a glass in story.
No. We just want to first say that what was recovered under section 27. Only Patari.
Patari and
wearing a
Gamusha.
Just Patari has been marked as MO6. And it is as for seizure list exhibit. Mr. Tripathi?
Exhibit 18.
Exhibit 18.
Exhibit.
Let us go to 18 now. Exhibit 18 is in which paper?
Exhibit 19.
Huh?
Exhibit
19.
19. Page, my lord.
Wait. Exhibit 19 is in which
Volume 2.
Volume 2.
Page 291.
291.
291.
Just a minute. ଗୋଟିଏ ଲୁହାର କଟାରୀ ଯାହାର ଲମ୍ବ 36.5 cm, ଓସାର 5.5 cm, ମଝି ଧାର ଚଉଡ଼ା 4 cm, ତଳ ପାଖ ଚଉଡ଼ା 3.5 cm, ରକ୍ତ ଲାଗିଥାଏ। ଗୋଟିଏ ପୁରୁଣା ରକ୍ତ ଭିଜା ଗାମୁଛା, ଦିଟା ଜିନିଷ। So this is exhibit 19, Kottari and Gamucha. This is the only thing which was recovered at your instance, nothing else. Page 292, during investigation of the case, seized as the accused led the police team and the witnesses and showed the place of concealment in present of as noted. So who is that accused? From the person and production by accused is Babuli alias Prakash Behra. So that is appellant number 1. Okay. And some who are they?
PW.
Girish Chandra Naik. Number Sakhi.
11 and below 35.
PW?
Girish Chandra Naik kete?
PW 35.
PW 35, Girish Chandra Naik. Mr. Tripathi, please check it.
Yes.
Girish Chandra Naik is PW 35 and BP Naik is?
Believe Sakhi, madam.
No.
PW 11.
PW 11. And the seizure list has been prepared by Premananda Lenka, Inspector of Police. We are looking at page number 292, the seizure list. Premananda Lenka is PW?
PW 41.
41. So far as this seizure list is concerned, 3 witnesses are relevant. 11, 35 and 41, right? Okay. So if we will come to the, you say that one Katari and Gamusha was recovered at the instance of the appellant number one, Prakash Behra, and no other material was recovered at his instance. What about appellant number two, Nanda Kishore?
Only basis of the work statement, no material.
No, we are asking about the recovery. At his instance, on the basis of a statement under section 27 of the Act, anything recovered? No. Anything was recovered from his possession, like wearing apparel?
Wearing apparel.
Let's say I turn to page 296,
296.
starting from page 295. That is seizure list. Prepared by the same.
This is so far as appellant number two is concerned.
Appellant one is concerned. Prakash Behra.
Acha.
295 ରୁ ଆରମ୍ଭ ହେଉଛି 296 ରେ ଓଡ଼ିଆ ପର୍ସେଣ୍ଟ ଅଛି।
ଆଚ୍ଛା।
ଉପରୋକ୍ତ ମକଦ୍ଦମାର ତଦନ୍ତ ସମୟରେ ଆସାମୀ ବାବୁଲି ଓ ପ୍ରକାଶ ବେହେରା ସାକ୍ଷୀ ଓ ପୋଲିସକୁ ଉପରୋକ୍ତ ସ୍ଥାନ ଦେଖାଇ ତାର ରକ୍ତ ଭିଜା ସାର୍ଟ ପ୍ୟାଣ୍ଟ ପୋତିଥିବା ସ୍ଥାନରୁ ବାହାର କରି ଆଣି ଦେବାରେ ସାକ୍ଷୀମାନଙ୍କ ଉପସ୍ଥିତିରେ ଜବତ କରାଗଲା।
Just a minute. Only this exhibit 19 is relevant, but also this is exhibit 21 na? Kete number?
Eta kya?
Exhibit page dekho then the page of
21.
Okay. So erase exhibit 21. Now, please come to even 296. Just a minute. This is another subject. Each seizure list रे page 296 रे दा जना पड़ी जो माने साइन करिसेंती जनक नाम होची सुरमणि प्रधान has he been examined as a witness? Judgment रो index टा देखी लियो तो
सुरमणि एक मिनट
नहीं सुरमणि प्रधान please see the witness name
सुरमणि नायक होची फुटर 22 मिनट
सुरमणि इट लिखा है सुरमणि
Peter 36 शिरोमणि प्रधान
सुरमणि then TW 36 is Pete Suramani Pradhan.
Subarna Pradhan.
Not Suramani.
Subarna.
It's not same person. Bappa na dekhile?
Subarna.
Tab ye aro seizure list onuje
Subarna Pradhan.
tab bappa na hochi Dhaneshwar Pradhan. Same person or different person? Suramani has not been examined. All right.
Suramani Naik is there. One Suramani.
No, we are concerned with Suramani Pradhan. He is the seizure witness. No?
Suramani Naik was the inquest.
No, he is not. He has not been examined.
He has not been examined.
Now you come to the next witness. The next witness name is Israel Sahoo. Whether he has been examined?
Israel Sahoo is examined.
PW?
PW 15.
PW 15.
15. 15. PW 15.
Yes.
And of course, the same investigating officer
41.
That is PW 41. So two witnesses are relevant so far as this seizure list is concerned. One is PW 15, the other is the IO, that is PW 41. So that's all. So far as seizure is concerned, Mr. Tripathi, these are the two seizure lists which are relevant for appellant number 1.
Yes, ma'am.
Right? Now we come to the appellant number 2. Nanda Kishore Sethi. Anything recovered at his instance?
Yes, ma'am. Where is the appeal?
What is that seizure list?
Exhibit minutes. One.
Exhibit 1, page number
264.
which paper book?
Volume 2.
Volume 2, 264. On production by accused Ranjio. Mishra City, right? ଗୋଟିଏ କଳା ରଙ୍ଗର ଫୁଲ ପ୍ୟାଣ୍ଟ ଯାହାର ପଛ ପ୍ୟାକେଟ ଉପରେ ଓନ୍ଲି ଲେଖା ବା ଷ୍ଟିକର ଲାଗିଥାଏ ଓ ରକ୍ତ ଲାଗିଥାଏ। ଆଚ୍ଛା, so this serial list এটা হচ্ছে dress exhibit 1 is the serial list. Now you come to the names of the witnesses in that serial list. Exhibit 1. Prashant Kumar Pradhan has been examined.
Yes,
As PW
2.
And what about Jitendra Pradhan?
PW1 Miller.
PW1. And of course this IO is the same IO.
Same.
That is PW 41.
41.
So is this the only which so far as PW 2? Mr. Tripathi?
Yes.
Any other serial list? Okay. So apart from the seizure of the dress and the cutlery at the instance of appellant number 1, Prakash Behera, what are the other materials? Last thing.
PW 37.
Just a minute. We are taking note of it. Last scene deposed to by whom? No. Witness number.
PW 37.
Only witness.
No.
PW 37. And of course seizure list. Seizure list relevant issue.
Exhibit 1,
so far as appellant number 2 is concerned.
1921.
Exhibit 19 and 21, so far as appellant number 1 is concerned. Yes, what else is there?
The DNA test report is there.
3 is the DNA test report.
PW 40 is
Just a minute, DNA test report. It is marked as exhibit
43. 43 by 1.
43 by 1.
Exhibit 59. Sorry. Exhibit 59. Exhibit 59. 59. Exhibit 59, page 349. Exhibit 59, page 349.
Just a minute.
359.
Page केते बोलूँगी?
349.
14.
349. Second volume bro.
Second volume.
DNA test report 349. Let us come to that. It starts at page 349.
349.
So what are the findings? 349 and 350 and it relates to the description and sources of the exhibits. Method of examination is there. We are concerned with the findings.
Paragraph 5, 6, and 7.
Page number.
Page 359.
358. Just one.
358. Conclusion paragraph.
Conclusion. ପଢନ୍ତୁ ଗୋଟି ଗୋଟି ପଢନ୍ତୁ ତାପରେ ଦେଖିବା ସେଟା
Following conclusion drawn from the test conducted on exhibits marked as A1.
ଛାଡି ଦିଅନ୍ତୁ ଫାଇଣ୍ଡିଂ ଟା ଆସନ୍ତୁ ଏକ ନମ୍ବର as per biological examination
After biological examination, exhibits marked as A, B, C, D, F, G, H, J, K, A1.
so and so contain blood stain of human origin. Hello.
IOC reports biologians the enclosure reference.
Okay.
Next, the DNA profile generated from exhibit marked as A, copies from Sari of deceased is of a human female origin, which cannot be compared with exhibit marked as A. 10 are from part of it, where the dead body of Sarina was.
It is cannot be compared. Leave it. তারপরে
10 at
3 number.
The DNA profile generated from exhibit C. 10 from Pokonda Beach, where the dead body of Viran was lying, is of a human male origin, with single allele dropout, allele 11 at locus CSF 1 kilo at serial number 4. Reference Journal Forensic Science, July 2004, volume 9.
And matching with the DNA profile generated from exhibit A. আচ্ছা এটা ডিসিজ সাংরে ছাড়ি দিন তারপরে আসন্তু
5 to 4.
ওটা পড়তাম
Mark a J. 10 are collected from Bidi Munda Sai jungle, where the dead body of Nabo alias Ecolobia was lying. A mixed DNA profile has been generated with dropout DYS391 locus and a single allele dropout.
এইটা be say DC sort of the deceased ones. So
5.
আচ্ছা 5 question that is
DNA profile generated from exhibit Mark N. SC from Patari, male origin, is matching with DNA profile generated from exhibit M1, copies from the start of deceased Ecolobia.
মানে এই কটারিরে যে ব্লড স্টেন আসিলা তার ডিএনএ প্রোফাইল ম্যাচ করুছি ডিসিজ নবসাইত ওকে দেন
DNA profile generated from exhibit Mark O, copies from the napkin of accused Bapuliale with dropout at DYS391 locus. Reference Journal of Forensic Science, July 2004, volume 49, number 4, 2ETALTP 733740, is a human male origin at 23 numbers of loci. The DNA profile of its A1, copies from start of deceased Nabo alias Econo.
তার মানে প্রকাশ বেহেরার যে গামুছা যে তা দেহରୁ যে রক্ত লাগিଥିଲା সেই রক্ত হଉଛି নব বা একলব্য নাୟକର রক্ତ ସେଟା ଲାଗିଥିଲା ଏ ଗୋଟେ this is the one of the important circumstance, right? And
also next one
7 yes.
DNA profile generated from exhibit Mark Q, copies from full band of accused alias Nandakis Seti. He is a human male origin, matching with DNA profile of exhibit L1, copies from the onion of deceased Virajini.
আচ্ছা তেণু নন্দকিশোর সেঠির ফুল প্যান্টরে যে রক্ত লাগিଥିଲା সেইটা হচ্ছে ডিসিজড বিরঞ্জি নায়ক, রাইট? সো দিস ইজ অলসো রেলেভেন্ট। তারপরে
DNA profile generated from exhibit Mark H, copies from hand gloves from roadside of Pokonda Beach, is a human male origin, matching with DNA profile generated from exhibit M1, copies from start of this.
That is Mr. Tripathi, I think this finding number 6 and 7. These are the relevant so far as the appellant's connection with the deceased blood. Right? Others are, it's all right. So these circumstances must have been put to you also in the 313 statement. Anything you have explained, how the bloodstain of the deceased persons in your napkin or in your pant. Only one. आगे प्रकाश बेहरा को पढ़े आसंतु प्रकाश बेहरा से पर्टिकुलर जो सर्कमस्टांस जो डीएनए रिपोर्ट करे इची क्वेश्चन पुट ही चाहिए
Who was the witness for proving the DNA report?
नहीं जो सुचिस्मिता बेहरा साइंटिफिक ऑफिसर
Have you examined?
जी सी एग्जामिनेशन थी वो इज दिस पीडब्ल्यू
Smita
Behera. Not exact. Then who has proved this DNA?
How have we exhibited it?
How
have we exhibited it?
Prashant Kumar Pradhan. SPW 40? 40. Prashant Kumar Pradhan. Scientific officer.
Expert witness.
PW
Scientific officer.
PW 40. 40. So this DNA report has been proved. PW 40. Prashant Kumar. Pradhan. Okay, now we are asking you that whether this specific question to this circumstance or the finding in the DNA report has been put to the concerned accused persons. Prakash Behera को पाया सुनते प्रकाश बेहरा accused statement कहाँ है?
Volume 1.
हाँ ये पेज नंबर कितने? 19. हाँ नहीं से यू क्वेश्चन था
147 question number. Page 40.
140. It transfer from the evidence of PW 40.
At page 40.
Yes. PW 40. You are talking about PW.
Page 40. Question number 147.
Yes.
It transfers from the evidence of PW 40 Prashant Kumar Pradhan that on 10/10/2017 SP Dhenkanal directed him over telephone on the request of SPO at Malik to produce 3 different spots such as Gambhari dwelling house and nearby Horoda plantation field where dead body of Tarini was lying. Crime scene 1, Pokhanda bridge where dead body of Biranchi was lying. Crime scene 2 and Gothamundia jungle where dead body of Ekalabe was lying, and prepared the report by exhibit 43 and collected materials from the 3 spots by seizure list marked as exhibit 29, 30, 31 and 32, which is signature marked as exhibit 29 by 2.
No, that is not.
Exhibit 59.
143
No, exhibit 59 you talk about it.
ये जो अपन को DNA टेस्ट रो फाइंड को क्वेश्चन टा पचराई जिमो जे तम रक्त रे तम गामुछा रे जो रक्त बाहरिला से रक्त होउची अपेक्षा पर जणागला से रक्त होउची नव ओरफ एकलव्य नायक रक्त जोटा कि ता सार्ट रु बाहर थिला से रक्त संगे तमरो मैच कला ए विषय तुम कौन कहया एक क्वेश्चन कोड
क्वेश्चन नंबर 141 42 and 43 मिनट पेज 41 40 41 42 and put
Exhibit 59 please.
Page 41.
141. Read it in transfer from evidence of period 30 to the blockchain blue color pen to
No.
59. Exhibit 59.
Exhibit 59.
Please take note of it. It's a very relevant thing or to put the question to the accused so that he will get an opportunity to explain it. आपण को accuse को पचारिया अच्छी जे कमो गामछारे
number 229 madam 229 page 54
just a minute 229 এটা কোন সেই accused अरे बाबा सेठ दीटा परा अछि आपनकर गोटे accused रो सरी जाईची पेज 56 रे आरो accused रो आरंभ होची नंद किशोर 57 पेज रे
पेज 50 पर है
54 question number 229 but it is in regard to the IO statement. 41 is the IO, PW 41 is IO.
No, that is not this. It is a DNS set smart so
page 55 mail at the same accused person Prakash Behra further statement page 55 towards the bottom question number 4. It transferred from the SFSL report exhibit 59 that on a report the blood stained hands gloves found at spot matched with the blood stained on shirt of MO9 of the deceased Nobo Ekalavya Naik and blood stained earth found at the third spot and also blood stain found on the weapon of offense that is Kotari Koturi MO6 and blood stain found on the napkin Gamucha MO7 both recovered at your instant. What you have to say, Mishra?
So this is the relevant question.
Yes, and next question also. It transferred from 5, question number 5.
It transferred from SFSL report exhibit 59 that all the exhibits that is exhibit A, B contain blood stain of human origin. What you have to say? What you have got to say? Answer, Mishra.
Yes.
Blood stain, acha. Now you come to the similar thing so far as the other accused is concerned. That means appellant number 2, accused Nanda Kishore Sethi. Jaro accused statement आरंभ होईची page number 57.
Let's see, turn to page 93 Miller.
93.
Again. Question 5 and 6 Miller.
Same.
So DNA test report blood stain found on the second spot.
Second spot matched with the blood stain found in the half banyan MO5 of deceased Biranji and your blood stain black color pant MO23. What you have got to say? More of pant shirt
police jabat
It transfers from the SFSL report 59 that as per DNA report the blood stained hand gloves also found that second spot matched with the blood stained shirt MO9 of deceased Nobo Ekalavya Naik and blood stained earth found at third spot and also blood stain found on the weapon of offense that is Kotari Koturi found on Gamucha MO7 both recovered at the
and 7 question 7 also.
7.
Now Mr. You just come to those seizure list once again. Two seizure lists which are relevant for appellant number 1 is 19 and 21, right, Mr. Tripathi?
Yes,
Now you see the date of the seizure. Date of seizure is mentioned. First is both are seized on 12/10/2017. You come to page 291, column number 4. Date of seizure 291. Date is 12/10/2017, 9:30. And the other seizure list is page 295. It is 12/10/2017 at 10:45 AM. So gote taro jota jo लिफा कटुरीटा जबत है 12/10/2017 दिन 9:30 रे बैरागी नायक चाष जमीरू इंस्टेंस ऑफ द appellant नंबर 1 एवं सेई दिन 10:45 रे बाउंस बुदा भितर प्रॉपर्टी नंबर 4 रे लिखा है बाउंस बुदा भितरू आपनकर गोटे नील रंगर जीन पैंट जबत एवं गोटे सीमेंट कलर फुल शर्ट जबत एटा होची 12/10/2017 राइट when this weapon so also this wearing appellant 1 was sent for chemical examination. What is the date? Forwarding report को पढ़े आसुन. I think the forwarding report is at page number 343. केबे का डेट देखिए again. चौदह 12/2017 लास्ट टू देखो पेज नंबर
346
right.
Even
Page
three-
number 356 Raj, date.
At the top you will see. Please refer to memo dated 2017 of SDM advising dispatch of one.
346 रे last page रे signature ଅଛି 346.
So
So Mr. Tripathi, we just want to a reply from you. जे 12/10/2017 रे कटुरी जबत हैला पैंट शर्ट जबत हैला appellant number 1 रू एवं again page number 264 जो exhibit 1 से 12/10 दिन 12:15 रे appellant number 2 रंजो alias नंदकिशोर सेट्टी ताठू गोटे कला रंगर फुल पैंट जबत हैला जो थरे कि रक्त दाग एवं आपनकर से रक्त दाग मैच करूची डिसीज सहित तो जदि आपण 12/10/2017 रे जिंस जबत कले एवं ताकू पठेइले 14/12/2017 अर्थात 2 मास 2 दिन परे what are the evidence that how it was preserved with whom in what condition what and who has laid evidence that it was in safe custody and there no question of tampering with the seized document. Please take note of it and tell us that so the question that is put to you, seizure on 12/10/2017, forwarding on 14/12/2017, safe custody evidence upon con and invasion. first of all, delay, why there was delay in sending the exhibits to the forensic science laboratory, with whom it was kept, and in what condition. So, what the police manual says that if any incriminating articles is seized and in presence of the scientific officials, which is required to be sent to the medical examiner, then it should be sealed at the spot itself. And in presence of witnesses, it should be sealed. And if it is not possible to send immediately to the forensic science laboratory, then it is to be kept in Malkhana, police Malkhana. Then Malkhana register is maintained. Whatever articles is kept in the Malkhana, that is to be noted down, time, what are the articles kept in connection with which case it is kept, and when it was removed from that Malkhana to be sent either to court or to the forensic science laboratory or to the doctor for examination, whatever it may be. So, whether the prosecution has adduced any evidence either through the IO or through any police officer, whether it has produced the Malkhana register to show that all these articles which were seized under the seizure list, Exhibit 1 as well as Exhibit 19 and 21, they were in safe custody and there was no question of tampering with the same before it reaches the chemical examiner. So the entire path right from the seizure till it reaches the chemical examiner, that path is by adducing cogent evidence, so that the court has to be satisfied that no, there is no possibility of any kind of tampering. Karan apanako pakhare jodi weapon paile, bloodstained weapon apan paile, gote pant paigale, bloodstained weapon ru se pant re puchi, taku tampering karibar possibility अछि. तेणु पुलिस स्टेशन रे आपण रखुचंती कोठी रहिला का पाखरे यदि आनिबेनी ताल भी टैंपरिंग करिवार पॉसिबिलिटी अछि. तेणु when it is a case of triple murder and it is expected that the investigating officer or the investigation should be up to that standard, तेणु आपनकर ए विषय we want a reply from you that how it was preserved, because yes, it has passed as per the DNA and it cannot be disputed that it is the bloodstain of XYZ. Then a bloodstain जोटा कटरी रे लगी थिला जोटा की वेपन ऑफ ऑफेंस से bloodstain तार वेयरिंग अपैरल सॉरी तार नैपकिन ने मिलुची एवं एठु मध्ये गोटे डिसीज रो ब्लडस्टेन पैंट रु मिलुची हला जनकर पैंट रु मिलुची जनकर गामछा रु मिलुची किंतु जदि आपनकर एविडेंस लैक करिवो जे the articles were not kept, there is possibility of tampering with the same, then whether any importance can be attached to the DNA test report finding or not. Same modern aspect of देखिए. Now, Mr. Mulia, you said that one evidence is last seen, second item is seizure list, and third is the DNA test report. What else are there against these appellants for finding the Mr. Tripathi, is there any other material? No. These are the three. And also motive. No, tell us, we are asking you one by one. Yes. what are the evidence? If you say motive, then who is the witness who has stated about the motive?
Yes, madam.
So you say there is also motive behind the commission of the offense. So who are the witnesses?
PW 36, my lord. Subarna Pradhan.
PW 36.
Page 169 of volume 1.
Subarna Pradhan. All right, we'll come to that evidence. We'll come also to the evidence of last scene, etc. Now, anything else against any of the applicants? That's all, Mr. Aukichochi. So let us go one by one. First, come to the last scene. PW 37. For evidence to Siddha Padayasing. That is volume 1 or volume 2?
Volume 1, page 174.
174.
Sorry, 8 or 48. W 37.
Giri Kumar Sahu.
Yes, yes. Please place it.
On 2017, I was running a grocery shop at Thakur near a foreign liquor shop on 9/10 to 17 at about 9 p.m. to 9:30 p.m. These two persons, along with another, namely Biranji, had come to.
No, who is Biranji?
This is
okay.
Had come,
one of the deceased.
Yes.
There are three deceased, so one of the deceased.
Had come to the counter of the foreign liquor shop of Thakur. They have purchased liquor from the foreign liquor shop. Thereafter came to my shop to purchase water pouch, huge and throw glass and mixture. They consume liquor in front of me and they stayed at my shop for 10 to 12 minutes. At that time, they were asking to Biranji to go Kola Patronalai to see the melody. And the melody is not good at Thakurgarh. Thakurgarh melody bhala houni. Then all the three persons moved with a red color motorcycle. On the next day, there was a viral news through mobile phone that Biranji has been murdered. I have seen the said video shooting at my shop, and after 2 days of incident, I found image of these two accused persons whose new was viral through the mobile phone. I could identify the accusers along with the receipt from the viral video. As they had come to my shop on 9/10/2017, Monday, at about 9 p.m. to 9:30 p.m. They decided to go to see the melody on the way, Okonda reached home. Today, these accused persons are standing in the door. Witness identified the accused person. I was examined by the police.
The dead body of this deceased Biranji was found where?
Near Okonda Beach.
Much.
On next day, that is 10.
When it was found?
10.
When it was detected?
10 minutes.
Who has stated that it was detected on 10?
The 38. PW 38 also has said 176.
If you come to first information report at page number 13, first information report re laws time hochi 10/10/2017 दिन 11:15 information received at police station. देखिले page number 13 3B column number 3 bracket रे B लेखन information received at Swansea. से पर्यंत होची मोर भाई पुतुरार संधान मिलू ना केवल भाउज घरे मरिकिनी पड़ी आउ भाई अर्थात से जो बीरंची तार और से पुतुरार संधान मिलूनी सो ऑब्वियसली there was no discovery of the dead body before 11:15 से पर्यंत किसी नथिला तेणु
7:45
आपण केते बेले मिलिला किए कहूची से एविडेंस
176
176
It comes from the evidence of IU 176 at page 188.
just a moment. Which paragraph?
Para 2. The first seizure material was collected about 4:35 where the dead body of the man was lying. তার উপর প্যারাগ্রাফ দিতে হবে। On 10/10 I was working as a so and so. The seizure was made so and so. It is 10:45.
No, that means Ratire. Seizure was made by this on production of this one so. Seizure was made in connection with so and so 302. Seizure material is IO count which
IO at
190
188. Page 188.
Just a minute,
Para 6.
Wait. 188
para 6. Spot number 1. During my spot visit, I came to know that the dead body of a Biranchi Naik was laying under the Kokunda Bridge and the dead body of Nobal Ekalabya Naik was laying at Birimunda Sai Gotomundia jungle. I reported the fact to my official superior over phone. As per that instruction, I continued the investigation. The seized articles of first spot was left in Jima of the complainant in respect of 4 seized articles out of 7. The exhibit 16 is the said Jimanama already marked, and exhibit 16/2 is my signature. Despite the body of Arani Naik through Constable number sir, only the prayer for PM examination.
So when that
timing is there also.
That is at paragraph 9, Miller. Page
9?
Page 190, paragraph 9.
Yes.
After instructing OAPF Saroj Naik to guard the dead body, I left to the third spot and proceeded to the second spot. I reached at the second spot at 5:40 PM and visited with the scientific officer. At the second spot, I found a pool of blood at a distance of 2 feet east from the dead body of Biranchi Naik, and 2 blood-stained plastic ropes were made joint with knot.
अच्छा तमाने बिरंची नायक रो डेड बॉडी टा 5:40 से 5:40 अपराह्न 5:40 से मिली so he is right that FIR देला बेलको डेड बॉडी केवल जण कर थिला आरो दि जण कर मिल नथिला सेटा ता परे डिटेक्ट हि so now we come to the cross examination of that witness who has stated about the last scene, that is 175. Please come.
Prosecution by the witness. I cannot say how many customers have visited my grocery shop on 9/10/2007 from morning to night. These accused person had purchased article like water throw mixture or rupees 20 to 30. I was knowing only Prakash Bera, Babuli, prior to this case. I had a furniture shop at Thakurgarh market. I had no prior acquaintance with the other accused person on the episode. Police had not seen in document from me regarding my grocery shop, which is situated near to the foreign liquor counter. I had no prior acquaintance with the DC Biranchi. I cannot say the registration number of the motorcycle used by the person, but it was a vehicle of Hero Honda company. I do not remember the name of person from whose mobile phone I could see the viral video of this accused person. Company and of liquor which these 2 accused persons had purchased from the foreign liquor shop. Ranjan Prasad Singh is the owner of foreign liquor shop. I did not refuse.
He has been examined this anybody from whose shop, because as it appears that they first purchased the liquor from the foreign liquor shop. So nobody from the foreign liquor shop has been examined. Mr. Tripathi, anybody has been examined from foreign liquor shop? No. Now, so far as these 2 accused persons is concerned, what he says in paragraph number 3, that his previous acquaintance is only with respect to one accused, that is appellant number 1. So if he has got no acquaintance with appellant number 2, and he had seen him for the first time on that day, after the arrest, whether any test identification parade was conducted to establish the identity of this appellant number 2?
Okay. He identifies in the dog only. 175 at the top.
Because the doc identification was on 8th December 2023, and that is almost after the occurrence. The evidence was recorded on 8th December 2023, right? The man was seen on 9th October 2017, and that was seen for the first time. No TI parade has been conducted. If so, how far that court identification is believable, that also you have to answer.
The video was viral when? Because para 2 says I could identify the accused persons along with the deceased from the viral video as they come to my house on 9th and so on.
Anything has been seized, whether that viral video has been seized. On the next day, there was viral news through my mobile phone. So anything seized in that respect. Because he says that I could identify the accused persons from that viral video, right? By that time, if he has, he said that on the next day means on 10th, and
so twice he saw, first on 9th he saw, and 10th he identifies. For the purpose of identification on 10th, what is the evidence? The viral video, have you seen the video or anything of that sort?
By that time, the FIR has already been lost and investigation has commenced. So there would not have been any difficulty on your part, on the part of the investigating officer, when this witness was examined, his statement before police. 161 was recorded when? Whether the 161 forms a part of the paper books?
No, you just see, do you have 161?
It is there. That is in the paper book volume number 2. And it starts at page number 300. 364 পরে আছে রিপোর্ট পরে স্টেটমেন্ট গুড়া আছে 365 onwards ya নাডা কোনলা সাক্ষীর নাডা গিরিশ কুমার সাহু দেখন্তু কেতে পেজ রে স্টেটমেন্ট গুড়া তাপর ଅଛି তিনটা যে স্টেটমেন্ট মাত্র ଅଛି ଆଉ ନାହିଁ people want proof and writing ଆଚ୍ଛା ଆଉ କିଛି ନାହିଁ statement ठीक है जी गोटे स्टेटमेंट देखो या ना होची गिरीश कुमार साहू द स्टेटमेंट ऑफ आर्थ का करूनी हां
चार्जशीट दे बताती तो
का परे थी अपने प्रधान ने record आसी तो original record भारत statement of Girish Kumar Sahu 161 station or you can see the case diary from which the date of examination of Girisa will be found out. There is there in the (17 11 2017). As for the case diary, it is page number 279 से जो वाकम रे अछि ए 17/10/2017 रे रेकॉर्ड ହେଇଛି तार स्टेटमेंट बाहर तो 17/10/2017 PW37 161 CRPC statement recorded on 17/11/2017. From the case diary, it reveals Mr. Mulia and Mr. Tripathi. It देखुची 17/11/2017 रे गिरीश कुमार साहू को एग्जामिन करची स्टेटमेंट अंडर सेक्शन 161 is enclosed here with. So आपनकर से साक्षी घटना विषय रे जदियो इन्वेस्टिगेशन 10 तारीख रु कमेंट्स ହେଇची 10 अक्टोबर तार मासे केते दिन परे पुलिस पाखरे स्टेटमेंट देइची जे मु देखिथिली बेल पाइलो
टू विटनेस गिरीश कुमार साहू और गिरीश कुमार साहू दिस इज गिरीश कुमार साहू
गिरीश कुमार साहू बापा ना सहित पे जणा पड़ुची मुड़िया साहू ये स्टेटमेंट आउची मुलिया साहू दियन पूरी ताकता मरी ना कहीं वहीटा कारण बड़ फ्लैग total different statement. He has not named even the apparent number one, not named even the deceased. The statement of she, Mr. Tripathi, you examine that statement 161. Have you got that statement? Why you are preparing? This is the only answer. Give a copy to the both the council. No, Girish Kumar Sahu.
Girish Kumar Sahu.
Achi, what on the statement of him?
गिरीश कुमार साहू आज 7/11/2017 तारीख आपण निकट रे मोर मौखिक बयान एकी जे मोर ठाकुरगढ़ पुराणा ढिय नागा मठ विदेशी मद दुकान सामने रे गोटी किराना दुकान अछि सब दिन राति 10टा पर दुकान बंद करे 9/10/2017 सोमवार राति रे ठाकुरगढ़ लक्ष्मी बाजार ऊपर मेलोडी चलुथिला राति 9:30 तीन लोक गोटे मोटरसाइकेल आसी मधुरेंद्र
तीन जण
दुई जण
कहूँ
ନିଜ ଲୋକ ଗୋଟେ ମୋଟର ସାଇକେଲ ଆସି ମଦ ଦୋକାନ ପାଖରେ ମୋଟର ସାଇକେଲ ରଖି ମଦ ଦୋକାନରୁ ମଦ କିଣି ତାପରେ ଦୋକାନରୁ ଆସି ମୋ ଦୋକାନରୁ ପାଣି ପାଉଚ୍ ଜରି ଗ୍ଲାସ ମିକ୍ସଚର ଗୋଟେ ପ୍ୟାକେଟରେ କିଣିଲେ। ସେତେବେଳେ କଥା ହଉଥିଲେ କି ଠାକୁର ଗୋଟେ ମେଲୋଡି ହେଉନି ଆମେ କଳା ବଟନାଳି ଦେଖିବା ଯିବା ଚାଲ। ସେମାନେ ରାତ୍ରି ମାତ୍ର 10-12 ମିନିଟରେ ଏହି ଚଟାପଟ ହୋଇ ପଳେଇଲେ। ତା ପରଦିନ ମଙ୍ଗଳ ଉପରବେଳା ଶୁଣିଲି ଯେ ଗମ୍ଭୀର ମଳିହାରର ଜଣେ ଲୋକ ଉପକଣ୍ଡ ପାଖରେ ମର୍ଡର ହୋଇ ପଡୁଛି। ତାପରେ ପେପରରେ ବାହାରିଲା ଯେ 3ଟା ମର୍ଡର କରିଥିବା ଲୋକମାନେ ଧରା ପଡିବା ପରେ ଲୋକ ସବୁ ସେତେବେଳେ ସେମାନଙ୍କର ଦେଖାଇଲେ। ମୁଁ ଫଟୋ ଦେଖି ଜାଣିଲି ଯେ ଏ ଧରା ହୋଇଥିବା 2 ଜଣ ଲୋକ ମର୍ଡର ହୋଇଥିବା ଲୋକ ସୋମବାର ରାତିରେ ଆସି ମୋ ଦୋକାନରେ ପାଣି ପାଉଚ୍ ଗ୍ଲାସ ମିକ୍ସଚର
Not taking the name.
In page 174, the deposition of Sahoo, he's saying 3 persons came.
No, but he has taken the name of the first appellant.
He stated that I know this man. This is most important. ମୁଁ କେବଳ डिसीज्ड को मध्य जानिछि। सो आउ जने लोक मु जानिनी बट से 3 जन जका आस्तिले whereas the statement is that 3टा लोक आसिले 3टा लोक आसिकिनी सेठू मद पीले मद पीकिनी जे तापर मो दुकान को आसिले मो दुकान रे पानी पाउच जो नेले तापर से माने कथाबार्ता में मेलोडी देखिया जाउछु मेलोडी तापर से पळेले।
According to his statement in 174, he knew the deceased as well as Prakash. That doesn't take the name of either the deceased or the first appellant.
Who was conducting this case? State Defense Counsel. He has not put any questions. This is a very vital question that should have been put to the witness, that you have neither named the appellant Prakash Behera nor the unfortunate part is that the trial courts, when they know that this type of cases are there, they should engage some competent counsel to conduct the cases. Where it's a case of triple murder and there is likelihood of imposing death sentence. Please read the cross-examination once again.
I cannot say how many customers had visited my grocery shop on 9/10/2017 from morning to night. These accused persons had purchased articles like water pouch, used and throw glass, and mixture worth ₹20 to 30. I was knowing only Prakash Behera, alias Babuli, prior to this case, as he had a furniture shop at Thakur Road Market, and I had no prior acquaintance with the other accused persons.
You see, Mr. Tripathi and Mr. Mulia, এই जो लाइन प्रथम रु जदि पचरा जीवो
कॉन्ट्राडिक्टरी अछि
9-10-2 दिन राति 9टा रु 9:30 भितरे एई 2 जण मुदाला
along with
डिसीज जा ना होची बिरंची मो काउंटर को आसीथिले एवं सेडमाने एआईया किनिथिले ए विषय रे तमे पुलिस बाबू को पाखरे स्टेटमेंट देइनो
एटा पचेरा कथा ना
दिस शुड हैव बीन द वेरी फर्स्ट क्वेश्चन टू हैव बीन आस्क्ड तमे कहितलो जे 3 जण लोक आसिले एवं 3 जण लोक ए जिंस किनिनि पळेले यू हैव नाइदर नेम्ड एनी ऑफ द accused nor the deceased Biranji. This has not been put to the. Now you read it. I had no prior acquaintance with the accused Nanda Kishore Sethi. That is appellant number 2. So no TI period has been conducted. Now you come to paragraph number 4.
Police had not seized any document from me regarding my grocery shop, which situates near to the foreign liquor counter. I had no prior acquaintance with the deceased Biranji.
Now he admits, of course, the error. Prior acquaintance आ संगरे नहीं कि prior acquaintance नहीं नंद किशोर सेठी संगरे. Right? The Mr. Tripathi, just take note of it. He has no prior acquaintance either with the deceased Biranchi or with appellant number 2, Nanda Kishore Sethi.
But in the same time, in the first paragraph in the cross examination chief, he says that Biranchi had come.
Biranchi had come with these two accused.
As if he knew Biranchi. Just see the first paragraph. Namely Biranchi. That these two accused persons along with another, namely Biranchi, had come. And this in juxtaposed with the cross-examination 4, you will see the contradiction comes.
Because you are to take into also Rati Samaya. ନଅଟା 30 ଭିତରେ ଏବଂ ତା ଦୋକାନ ପାଖରେ ରହିଛନ୍ତି 10 ରୁ 12 ମିନିଟ। ଏଇ 10-12 ମିନିଟ ଭିତରେ ସେମାନେ ତା ଦୋକାନରୁ କିଣିଛନ୍ତି ୱାଟର କିଣିଛନ୍ତି ଆଉ ୟୁଜ ଆଣ୍ଡ ଥ୍ରୋ ଗ୍ଲାସ କିଣିଛନ୍ତି, ମିକ୍ସଚର କିଣିଛନ୍ତି, ତାପରେ ସେମାନେ ପଳେଇ ଯାଇଛନ୍ତି। ସେଇ ଯୋଉ 3 ଜଣ ଭିତରୁ 2 ଜଣକୁ ସେ ଆଗରୁ ଟୋଟାଲ ଦେଖିନ, ତାର ଆଡମିଟ କରୁଛି। 161 ତ କହୁଛି କାହାକୁ ବି ଜାଣିନି, 3 ଜଣ ଅଜଣା ଲୋକ। এই স্টেটমেন্ট যদি আসিলা তো ইভেন ইফ ডিসিজড পাই মধ্যে ডিসিজড র ফটোগ্রাফ মধ্যে আপনকু থিলা যে চিহ্নিবা তাকু যে जो लोक संगे ये आइथिले या भितर कोनोसी फोटोग्राफ तार ये करछि कि तो डिसीज फोटोग्राफ को सी आइडेंटिफाई करिवार तला जे एई जो डिसीज एई ही आस्तला मो दुकान को से दिन राति रे। So na photograph identification of the deceased has taken place, na Nandakishore Sethiro TI period heichi because he knew had no prior acquaintance with him and he had seen him on that day for the first time and just to 10 to 12 minutes in the night hour. We do not know what was the source of light in his shop. There is no evidence. There is no, whether it may be a lantern, it may be a lamp, or it may be a bulb also. So, केते समय से लाइट को सोर्स रो लाइट थिला जो थ्रू की तार पावर मेमोरी पावर एते थिला कि हमें बिलीव करिवु जे ए लोकटा को पॉसिबल हबो जे 2017 मसिया रे से देखिछि एवं 2023 मसिया रे से डिपोजिशन करिला बळकू ताको आइडेंटिफाई करि परिबो इन कोर्ट। आर यू फॉलोइंग अस? सो ए एविडेंस गुडा को आपन को सैटिस्फाई करिया को पड़ो। तनु लास्ट सीन,
this is the only witness for last scene, nothing else.
No, yes. As such, it is said that last scene is a very weak piece of evidence. आपनकर जो जगह रे देखा हला ता पर दिन प्राय लेट अस से 17-18 घंटा परे डेड बॉडी मिलुची कारण डेड बॉडी मिलुची 5टा बळकू। तेणु I think that this question has been put to the accused. This evidence of PW 37 must have been put, and what is his reply? Whether he has admitted that yes, I was in the company, or he has stated no, Michogata.
Yes, page 37.
No, what is his reply?
No.
To the evidence of PW 37?
No.
Michogata? No. All right, he has not stated anything, but time gap is also very relevant in the last scene. कारण এই 3 জন যদি এই গোটে পার্টিকুলার প্লেস রে এই সময় রে দেখাই থানতে তার କିଛି ସମୟ ପରେ ସେଇ ଜାଗାରେ ଜଣଙ୍କର ଡେଡ୍ ବଡି ମିଳିଥାନ୍ତା. Let us say we three are there at a particular spot at a particular point of time, and after few hours, 1 or 2 hours, at that very spot the dead body was found, one of us. Then we have to say that what happened to the other two. The other two has to say that how he died of homicidal death. Last scene hochi jaga hochi A re. Dead body miluchi ta paradino B jagare. We do not know what is the distance of the place of last scene from the place where the dead body was recovered. So the possibility of third person coming in contact with the deceased cannot be ruled out. He has not offered any explanation, it's all right. Whether to see that whether these possibility is there or not. Last scene evidence को utilize करियाको हेले एमिति दरकार जे time gap should be short, and the place where the last scene and the dead body was recovered, that is also should be very close to each other. If that material is not there, and if at another place we do not know what is the distance, the dead body is recovered, whether that can be utilized as last scene, because the possibility is there. There are you can find out the issue. The possibility of the third person coming in contact with the deceased in such a situation cannot be ruled out. These are because of this time gap, because of the place from where the last scene was there and the place where the dead body was found. Hala? Katak re last scene hala. Bhubaneswar dead body milgo. Ta parodino. The possibility achi deceased Bhubaneswar avkar contact rasti. So that also you have to satisfy. That apart, the source of light, because he was having a cabin in which he was selling the water pouch, use and throw glass and mixture. ତେଣୁ ରାତିରେ 9:30 ରେ ଏ 3 ଜଣ ଲୋକ ଯୋଉ ଆସିକିନି 10-12 ମିନିଟ ରହିଛନ୍ତି ପାଖରେ, what was the source of light that gave you that can get the confidence of the court, or will be satisfied that yes, who had come on that day at that point in time, so that he could be able to identify them after 6 years and 2 months. Right? 2017 मसीहा source of light not known, identification accused को होसी 8-10-2023. So 6 years and 2 months after. So how far this identification in court is to be accepted if there is no TI period, right? That also you have to settle.
Has the trial court culled out all the circumstances in its judgment? No. You see, in the judgment has it culled out? Yes, madam.
Volume 2.
Huh?
Volume 2.
Volume 2.
Second volume.
What are the circumstances?
Page 225.
225. Yes. Yes. Hey, what are the circumstances, sir?
225. 225 in the second volume.
There are two circumstances.
Last
Yes.
paragraph. Towards the bottom.
These circumstances are lasting theory and DNA report. These are the two circumstances.
And in addition to that, he has stated about the motive,
And also DNA report.
seizure, of course, you have stated, right?
Yes.
So
now, and statement on section 27 at page
that is there.
Double
Seizure. He and Mr. Mulia, we are keeping this matter to 30th of June. On 23rd of June 2025. Right? And it will be taken off at 2 p.m. But we are passing this order and the copy is to be handed over to you so that you call for those reports and you also file the affidavit. And we are giving that date to up to 30th. ଆପଣ 30 ତାରିଖ ପର୍ଯ୍ୟନ୍ତ ସେ ଯୋଉ affidavit reports collection କରନ୍ତୁ. But in the meantime, we will continue with the argument, right? 2 p.m. Because in the first half we are taking up the writ petitions. In the second half we are taking up.
Then only two circumstances, one motive. That's all.
अच्छा ये criminal appeal बाहर करो. प्रकाश बेहरा नंदकिशोर सेठी आपनकर आज सुनानी आरंभ है आमे कहिचु जे आपन को जो विषय रे सत्यपाठ दवा को पड़िबो से विषय आपन देबे आउ सरकारी वकील महोदय से मध्य तांकर विभिन्न विषय रे से रिपोर्ट देबे प्रोड्यूस करिवे सेटा 30 तारिख दिन भितर सेटा को दबा को पड़िबो आपन को सत्यपाठटा किंतु ये जो सुनानी आज आरंभ है एटा पुणी 23 तारिख दिन को रहिला एवं दिन 2टा बेले सुनानी हबो एवं आपन को एमती आपन हाजर हेबे आ जो वकील बाबू अछंती दिलीप बाबू आपन मध्य से दिन उपस्थित रहिबे जहा ए आर्गुमेंट चलीची से बाबू मान को बुझीबे बुझेई देबे एवं से माने जदि किसी चाहूचंती वकील बाबू को जणेवा पई से विषय मध्य आपन जणेई देबे. ठीक अछि. 23 तारिख दिन 2टा बेले पुणी सुनानी चलिबो. ठीक तो अच्छा ओके. So any other materials which the fresh admission अछि. So what is this matter? Item number 2.
Advocate and
No, it's all right. But what is the offense and what is the conviction? P02, life imprisonment. So we are condoning the delay. And the stamp reporter has pointed out that there is delay of 150 days in filing the jail criminal appeal. Considering the fact that the appellant has been sentenced to life imprisonment, we are inclined to condone the delay Accordingly, delay is condoned. Third, admit call for the trial court record. So is engaged as the counsel for this also. Intimate dealing. So right over now to a BIU obviously. Yes, now come to the second one.
302-201 34 convicted and sentenced to life.
Right, this is admitted and call for the trial court record. Interim applications for bail and stay realization fine to be considered after receipt of the trial court report. Deposition copies to be supplied in the meantime. Yes, next.
Item 4.
302. Same order. Next.
Item 5.
302 life permission. Same order.
Item 6.
Stay realization of finance. It will be considered after it is received. We will consider the bail as well as stay realization. 6. Delay condone, admit, and counsel is to be engaged. Same is item number 7 also. Delay condone, admit. These are all life imprisonment cases. You have checked it out. All.
Up to late.
And item number 8 also same. Delay condone and admit.
169 days.
And counsel is to be engaged. Yes, in
169 days.
this is all right. We are condoning the delay. So these are all the sure. Rest of the matters. It will be taken up on Friday. It will be listed. Of course, you do not know this. There is likelihood that there would be a reference on that day because that is the last Friday, and 27th is a holiday. So what
another name is also added recently in that list.
No, so it will be, I think 2:55 the court will rise. So it will be there in the weekly list because tomorrow it's after lunch, this Cuttack PIL is there. So Friday at 2 o'clock is there, madam.
Item 14 modification.
What modification you want?
Your Lordship is to grant the interim bail to the applicant for 2 months, my lord. But it is written in para 7, my lord. Petitioner shall surrender before the learned trial court immediately on expiry of the 4 weeks period, my lord.
देखिए 15/5/2025 order.
Item 14.
Just one. दूर ले जाइए ना देखिए we are inclined to release the petitioner on interim bail for a period of 2 months from the date of release. The petitioner shall surrender before the learned trial court immediately on expiry of 4 weeks. So that would be 2 months. IN number
1449.
1449 of 2025. This is an application for modification of order dated 15/5/2025. The learned counsel for the petitioner submitted that even though this court, right, order dated 15/5/2025 in IN number 1131 of 2025 has granted interim bail for a period of 2 months from the date of release, but inadvertently it has been mentioned that the petitioner shall surrender before the learned trial court on expiry of 4 weeks period, and the same may be corrected so that the petitioner will surrender on expiry of 2 months period from the date of release. Prayer is accepted. The order dated 15/5/2025 is modified accordingly. The rest part of the order remains on order.